We'll start with the Pledge of Allegiance. Councilperson Kemp.
Please rise for the pledge.
To the flag, United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, this is a special council meeting, so we'll start with roll call and then we'll go into the public hearings.
Councilmember Kemp.
Here.
Councilmember Renagi.
Here.
Councilmember Whalen.
Here.
Mayor Pro Tem Jones.
Here.
Mayor Orgill.
Here. Thank you. So we'll open our first hearing of this evening. Appeal B, which is 1813 Temple Hills Drive. Oh, did I say A? I apologize. Appeal A. Let me get to that. Appeal A. 1550. No, that's C. No, Temple Hills, 1813 Temple Hills Drive. Thank you. Are there any disclosures for ex parte hearings?
Yeah, I spoke with the applicant and the appellant.
As did I.
I did as well, and had a brief text exchange with Steve Quartani.
I did as well, both parties.
I had a brief conversations with all three parties mentioned.
Great. Okay, we'll do staff presentation.
Good evening, Mayor and members of the council. Shweta Sharma presenting Appeal A for 1813 Temple Hills Drive, which is an appeal of design review 24-2113. The project is located in the R1, of course. The project is located in the R1 zone and consists of modifications to a previously approved design review board plan, landscape plan that was approved in 2012. The modifications to the landscape plan was approved at the February 13, 25 Design Review Board meeting by a 5-0 vote to conditionally approve the project. An appeal was filed by the neighbors at 1843 Temple Hills Drive. Before you is the landscape plan that was reviewed and cleared by staff, and that was approved at the February 25 Design Review Board meeting last year. The issue is with the plan is those ficus trees that are located along the property line that are shown in green. The appeal had 8 contentions, the first of which was that the project was a code enforcement mandated project regarding ficus trees that blocked an existing view corridor. The neighbors also contend that they were not informed of the board's approval. The third contention is the applicant held ex parte communications with staff and provided misstatements to the board. The fourth contention is staff did not visit the site and the plans were not reviewed by an expert who weighed in on the plans. The fifth contention is that the approval is a significant modification to the previously approved landscape plan, that there is code enforcement history of the case that was used against the appellant, that there was insufficient evidence to support the modifications to the plan, and that board members were confused about the specifics of the project. Staff will respond to the contentions raised in the appeal. Pursuant to the Laguna Beach Municipal Code section regarding design review, applicants are allowed to modify previously approved design review board plans as allowed by Code Section 2505.040B1Q. And that the applicant was required to apply and receive approval from the board for the modifications to the previously approved plans in order to resolve the outstanding code enforcement case at that time. The report and presentation noted that the project was a result of code enforcement and that pursuant to the code that they had applied and the plans had been cleared by staff. The report and the presentation noted that the board should deliberate on the view equity and the landscaping criteria to consider and potentially consider additional conditions of approval to address the concerns that were raised by the neighbor at 1843 Temple Hills Drive. Regarding the view equity criterion, the board approval as documented in the resolution gave due consideration to the proposed vegetation heights to ensure that view equity was met. Moreover, in its conditional approval for the project, the board properly considered the appellant's views across the applicant's property when it determined that the ficus trees would be capped at a maximum height of 25 feet. Secondly, the assertion that the board's decision is not final until the resolution is executed is not supported by law. The decision is final as a design review board publicly deliberates and makes the motion and votes at a publicly available meeting. The appellants were in attendance at this meeting and provided comments during the public comment period and would have been aware that the project had received conditional approval at the conclusion of the hearing. The city does not provide additional notice to neighbors regarding either approval or denial of any matters before the board. Communication with staff would not constitute ex parte communications, as staff is not a decision maker on any projects before the board and is regularly in contact with both project applicants as well as project opponents in advance of any public hearing. The board considers the entirety of the record and exercises its own discretion in reviewing each project individually. The record does not indicate that any allegations of harassment were considered in the decision-making process, and the deliberations focused on relevant design review criteria, specifically view equity and privacy. To satisfy both these criteria, the board granted a conditional approval restricting the maximum height of the ficus trees by setting a minimum height of 20 feet in order to preserve privacy and a maximum height of 25 feet in order to preserve view equity. It is unknown whether staff conducted a site visit in advance of the hearing last February. However, staff did communicate with code enforcement staff and was aware of the existing site conditions. In the February 13, 2025 staff report, it was noted that all relevant design review criteria were considered in staff's recommendation for the project. The appeal does not identify how the landscape plan may be inaccurate, nor was information provided by the appellant to the board during the hearing. As previously mentioned, modifications to a previously approved landscape plan can be requested upon submitting a design review application pursuant to the design review section of the Laguna Beach Municipal Code. The modified landscape plan was required and approved by the board, and the landscape modifications qualified for approval as determined by the board at their hearing and in their deliberations. These plans were cleared by staff and voted, and the board voted 5-0 to conditionally approve the project. The applicant was allowed to request the modifications to their previously approved landscape plan consistent with city procedures in accordance with municipal code. The board found that the requested changes as conditions satisfied the relevant design review criteria. The board considered the merits, weighed the evidence, and the decision was based on the required findings for the approval that was presented to the board. The appellant has not cited specific evidence to support conclusion that the history of the application influenced the outcome, and based on staff's review of the record, staff believes that the board's review was fair and impartial and gave due consideration to all evidence presented. The board took into consideration staff's analysis, testimony that was provided by the applicant, and public comments in their 5-0 vote to conditionally approve the project and in the adopted resolution. As indicated in the meeting minutes, 4 of the 5 board members also met with the appellant prior to the hearing, providing the appellant with additional opportunity to express their concerns with the project. The board applied the required design review criteria to the proposed modifications in their review and deliberation of the project. The board posed questions for applicant, staff, and the appellant during deliberation of the project. These questions were answered and understood. The material facts and relevant design review criteria on which the board assessed the project and conditionally approved the project. The record demonstrates that the board appropriately weighed the evidence and rendered a decision based on the required findings and that they understood the project specifics. Since publication of the report, an attorney for the neighbors has provided a letter stating opposition to the project due to procedural defects, abuse of discretion, mischaracterization of the scope, and safety and view concerns. As the project was conditionally approved by a 5-0 vote, tonight is not a de novo hearing. The city council is limited to the grounds specifically stated in the notice of appeal. The review is confined to the evidence that was presented to the design review board. The design review board's decision is presumed reasonable, valid, and not an abuse of discretion. The appellant bears the burden of proving otherwise by preponderance of evidence. The abuse of discretion definition is that the design review board did not proceed in a manner required by law, the decision is not supported by the findings, and that the findings are not supported by the evidence. Council has 4 options tonight. 1, to adopt the resolution upholding the decision of the board to conditionally approve design review 24-2113 and finding project categorically exempt under CEQA. To adopt the resolution upholding the decision to conditionally approve 24-2113, but modifying the resolution to include more restrictive conditions of approval. To direct staff to prepare and return at a future meeting with a resolution overturning the decision and denying design review 24-2113, or to direct staff to prepare and return at a future meeting with a resolution to remand the project to the board with further direction. Staff's recommendation is that the council adopt the resolution denying the appeal and sustaining the approval of design review 24-2113 for modifications to a previously approved landscape plan for an existing single-family residence at 1813 Temple Hills Drive, located in the R1 zone and categorically exempt under CEQA Class 4. That concludes my presentation. I'm available for any questions, as is the applicant.
Thank you. Do any council members have questions of staff? None? Okay, then we'll proceed. Open the public testimony, starting with the appellant presentation, allowing 5 minutes.
Yeah. Good afternoon, Mayor and council members. I'm Dr. Rhett Schiffman, the next door neighbor at 1843 Temple Hills Drive. In full disclosure, I'm also a member appointed to the View Restoration Committee. We have provided detailed written comments on this current staff report, which we believe to have a multitude of errors, and we cannot address each one of these beyond what's included here in the allotted time. Next slide. The first slide. Okay, the next slide. Okay. So with that, thank you for agreeing to hear our appeal and making time to conduct site visits to our property. These were our views in 2013 when the Velo remodel of the home next door was being completed. Next slide.
Can we make that larger on the screen?
The Velos routinely neglected their landscape, and after 2 years of negotiation and mediation, we were forced to file a code enforcement claim in January 2023 that resulted in multiple notices of violation and 3 citations. Next slide. This was the condition from our lower level at the time of the initial violation, with massive overgrowth of an evergreen ash and 2 illegal ficuses growing into a view corridor that was supposed to only have ground cover. This robbed us of all Catalina and Sunset views from our lower level. Next slide. And this is the condition from our upper level. Instead of the evergreen ash being 20 feet tall and 10 feet wide, it was 35 feet tall and 45 feet wide. This was obviously intentional and spiteful. Next slide. Code enforcement referred this case to a DRB to legalize the new ficuses. This was an error, as the new ficuses were never authorized by the original DRB. The DRB abused their discretion and asked for permission from the assistant city attorney to increase the height limit of these hedges from the requested 20 feet to 25 feet without any study, creating this egregious view impairment. The DRB also decided that these fast-growing hedges only needed to be cut twice a year. Next slide. They also improved an increase in the width of the ash from 10 to 20 feet. In so doing, they created a massive hedge in our valuable view corridor. Next slide. As for why the DRB behaved this way, the Vela agent Steve Kuratami appeared to have convinced the DRB in ex parte meetings that again at the meeting that we had planted those ficuses. This was untrue, and they knew it. And these photographs make that crystal clear. The Velas also claimed that we were using code enforcement to harass them. These are the event logs from code enforcement from the first 4 months after the initial notice, showing that there were 12 compliance visits, with 10 of these still showing non-compliance. The Velas simply did not want to comply. Next slide. However, the worst procedural error of all was that the comments from the city's own landscape consultant, Richard Ramsey, were not included in the staff report nor shared with the DRB, nor with us. These comments clearly say that the ficus is at just 20 feet, would conflict with hedge height limits, and that the disputes would have to be resolved in the city hedge height resolution process. And because this was ignored, the staff report wrongly stated that the proposal adhered to the design guidelines, and this error misinformed the DRB as to the substantial impact of their decision on our views. As the weather was severe and no story poles were placed, the DRB could not independently evaluate the impact of the proposal on the Schiffman views. That planner is no longer with the city. Next slide. Oh, boy. Sorry. The next procedural error is that the city processed an incomplete application as the application lists Kavita Reddy as property owner when the actual property owner is a trust. The council should vacate the approval for that reason alone. Additionally, accordingly, we respectfully request that the city council fixes this by vacating the DRB decision and either referring the case to a hedge height procedure for the new ficuses and evergreen ash as recommended by their own landscape consultant, or revise the maximum heights from the original DRB for the trees in the rear and side yard from 20 feet to 15 feet to be maintained at all times, consistent with Laguna Beach Municipal Code 12-1650, with reference points that are easily visualized from the Schiffman's property per the request of code enforcement, so that access to the Vela property is not required to determine compliance. And also to vacate the increase in the width of the evergreen ash so that this does not become a hedge again. Referring this case back to the DRB is not acceptable, as we cannot possibly receive a fair hearing with this DRB.
Thank you. Are there any speakers in support of the appellant? 3 minutes.
Dear City Council members, my name is Sherry Schiffman from 1843 Temple Hills Drive. I'm here today to speak about a long-term problem with my next-door neighbor, the Villa family at 1813 Temple Hills Drive. After a renovation in 2013, the Villa planted 9 trees not in the approved landscaping plan. Over 12 years, some trees have grown over our roof. Despite repeated requests, only 2 branches have ever been trimmed. These trees pose serious problems, increased fire risk difficulty, renewing homeowner insurance, potential damage to our solar panels, and ongoing stress. In addition, 2 or 3 trees were planted inside of a protected view corridor, blocking our ocean and Catalina Island views from our living room and master bedroom. The approved 2013 plan requires fence-lined trees under 20 feet and no trees in the view corridor. Yet the Vela family now requests the trees grow to 25 feet for more deck privacy. They have 4 decks on the 3 levels. We can see 1 from our deck. They are also visible from other homes and from the street below. The time they spend there cannot override the permanent impact on our living spaces. I want to mention a neighbor on another side of their property at 1797 Temple Hills Drive. During DRB review, the Vela family required the owner to lower the roof move the house closer to the street, relocate the garage, and keep the trees under 18 feet to protect their own views. This is part of a public record online. The homeowner was so discouraged that he sold the home without even living in it. This is a clear double standard. Strict protection of their own views, but ours are asked to be sacrificed. We have already compromised by allowing some unapproved trees to grow for more privacy. However, extending this further at the expenses of our reviews, safety, and peace of mind is unreasonable. The kind of behavior cannot be encouraged. I have collected signatures from neighbors who support our appeal today. DRB decisions are meant to ensure fairness between neighbors. I'm simply asking the city to enforce its own rules so our neighborhoods stay peaceful and respectful. Thank you.
Thank you. Are there any other speakers in support of the appellant?
Hi, good morning, Mayor, members of the council. Thank you for taking the time to be here today and hear this appeal. My name is Daniel Friedman. I'm counsel for the Schiffmans, and I'm going to provide a little bit more context and my take on the situation. First off, I want to say I think it's excellent that you guys went out there and met with both of the neighbors and both of the folks involved here. Ultimately, at the end of the day, everyone needs to be neighbors and live next to each other, and hopefully this gets resolved today in a way that is amicably acceptable. These view cases are always difficult, and I don't envy your position of having to solve them, but I believe you can do it today. Ultimately, I want to make just a few points. I submitted a handout. The points are already in front of you. Hopefully, you've had a chance to read them. Point one, I think where all of this stems from is the fact that this was presented as an increase of height of vegetation. So if you look back at the staff report to the DRB, and if you look at the staff report was presented to you today, it's presented to you as trees and vegetation, but it's not trees and vegetation. This is a clear hedge. And I think had it been presented to the DRB as we are doing a massive hedge, that would have been a different consideration. Now, why do I say that? Back in 2012, when this application was first heard, there was a hedge proposed. It's the one along Temple Hills Drive. And what did the DRB do? They limited it to 15 feet. They said, trees, okay, we'll give you 20 feet behind the street, but the hedge, 15 feet, no other hedges. When it comes back to DRB, it gets presented as just additional trees, not that we are now putting together a large hedge in the side yard. And that's how they voted, as if we're dealing with trees, not a hedge. And I think that was a clear mistake. With respect to the error, I also want to note there were no additional findings or evidence presented after the DRB decided to unilaterally increase it to 25 feet. They just said, can we do 25 feet? And the answer was, okay, why not? That was a problem. There were already findings in the record that said the maximum is 20 feet. Yet they didn't do any further analysis. They didn't look at any additional evidence. They didn't do anything further. They just said, okay, let's just let it go to 25 feet. And this was in the face of evidence that actually wasn't presented to them from the landscape consultant, which my client mentioned, specifically calling that this is a hedge. Request you also consider view equity. That is key. That is in your general plan. It is all about, and this is where I'll conclude, view equity, land use policy 2.10. The city's policy is to maximize the preservation of coastal and canyon views. And we ask that you consider that in your deliberations on this matter. Thank you so much, and we're here for any questions. Thank you.
Thank you. Are there any other persons to speak in support of the appeal? If not, then we'll move on to the applicant presentation, allowing 5 minutes.
Thank you. Could I get my documents just ready to go, please? Thank you.
Larry Noakes one.
Larry Noakes for Matt and Kavita, the owners of the applicant property. I wanted to, and good evening and Happy New Year. And I wanted to start out by just addressing something that Dr. Schiffman said, and it came up in Daniel's letter to the city too. It had to do with the trust standing. that the property is actually owned by the Rideau Trust, and that Kavita Reddy was the person who signed the application. I just wanted to say that that issue has been corrected by an authorization of the trust, and that has been submitted to the city, and we would ask you to make that part of the record. And that is slide 1. If we could go to slide 2, please. On the issue of the application that was filed by the Schiffmans, I was just kind of surprised to see them bring this up, because the application or the appeal that was filed by the Schiffman is filed in the name of Dr. Rhett Schiffman and his wife, Sherry Schiffman. Well, that property, if we could go to the next slide, please, is also owned by a trust. The next document, please, is the deed that shows that that property was transferred actually to trust by Dr. Schiffman and his wife. So, and no appeal has been filed in the name of the trust. It's only been filed in the name of the individuals. So if that's the rule, then that's the rule, I guess. In any event, it's also noted that and this was in the notice of appeal, that the appeal was filed on April the 1st. The appeal was the hearing was had on February the 13th. Obviously, the appeal was late, but we did consent as good neighbors to allow them to have this heard. I wanted to point out a couple of things now, getting to the merits, and hopefully we're past the procedural stuff. I watched the DRB hearing 3 times trying to find the error that they're talking about. And I couldn't find a single error that was committed by the DRB. So while there may be some motivation to appease the appellant so that they won't sue Matt and Kavita again, they won't sue the city again, it will not be due to any act or omission by Ms. Gannon or Mr. Gibbs or by Mr. Weil or by Ms. Thalman or by Ms. Coveney. That board acted as you would want your board to act. They went to the site. They went to both houses. They looked at the views. They considered the rules. They considered the design of review criteria and guideline and applied those criteria and guidelines faithfully. If we could take a look, please, at slide number 4. Next one, please. Okay. I thank the mayor for his brilliant photography, I think, on this. These are pictures that are taken from the Schiffman property. And as you can see, there are some poles that are up against the Vela Reddy house. And those are poles with marks on them. And I don't know if it's possible to zoom in or not, but there are marks basically at the 20-foot level. Could we go to the next slide, please? These lines are drawn through those points. And the lowest one is at the low level, and the higher one is 2.5 feet above that level. And if you take a look at the vegetation above this straight line, the lowest of the straight lines, you see vegetation in the far field. None of this vegetation, if it grew to these lines, none of this vegetation would block any view from this location. And if the vegetation grew up another 2.5 feet, it still would not block any view. It would block view of some other vegetation and perhaps some roof heights. Next, please. This line shows 2 feet above the marked position on the posts. And this shows, again, the same thing, that there's vegetation in the far field. This does not block views of Catalina. It does not block views of the ocean. It doesn't block views of anything except other vegetation. And if we could go to the next slide, please. Now, there has been a suggestion that there be some kind of topiary style modification of this hedge. But if you take a look at this, there are, I think, no fewer than 5 facets on this. There are horizontal and vertical facets. The Schiffmans have called code enforcement, I think, over 100 times on Matt and Kavita. And if there's a horizontal encroachment or a vertical encroachment, even a leaf, they will call again. So it's better to keep it simple. It's better to keep it maintainable and manageable. Just in closing, I would like to say that the hedge lines need to have a consistent height above the grade with trimming 2 times a year. Thank you.
Thank you. Are there any
Could,
persons?
could we go back a couple, Larry, to the slides
Sure.
with the yellow lines on them?
Yes.
Because when I was out there yesterday looking from the Schiffman's property, and then I went over to Matt and Kavita's property afterwards, not the one with the yellow lines on it,
Be the one
before that.
There.
Yeah. So there were red bands around, I can't see them from here, but there were red bands around that middle stake, which was 20 feet.
Right.
So 25 is 5 above that.
Correct.
So I don't understand what you're showing here.
I'm showing the 20 feet, we're showing the 20-foot line,
Not the 25-foot line.
not the 25-foot line.
Yeah, which
The
is what,
25-foot line is the top of the post.
which is what DRB approved it up to.
No, well, they said that it would be approved at 20,
20
but it
20
could
to
grow up to,
25.
but it could grow up to 25.
Right.
What I was.
No, I wanted to clarify. That's,
No, that's
yeah.
absolutely correct, Bob. And I think that 25 is basically the top of those poles.
top of those poles.
And
That's my understanding.
And what that was designed to do, I think, is just to give a little bit of flexibility with regard to the trimming schedule if they grew above, but the trimming still has to be 2 times a year. So I don't see them ever getting to that height. But what I did is I had a line drawn above the 20-foot level to 2.5 feet and then 2 feet, just to show that even in that situation, there's still no problem. I think Matt and Kavita are probably willing to go to a 2.5-foot buffer. They just don't want to don't want to have a hedge guy there every day cutting this down so they don't get
No,
turned
I
into
did-
code enforcement.
Good, I know, thank you. I just
You're
wanted
welcome.
to understand the facts there.
Thank you for the opportunity.
Thank you. Any other speakers in opposition to the appeal?
Good evening, afternoon, council members. My name is Kavita Reddy. I am the property owner at 1813 Temple Hills, along with my husband. Wanted to make a few points. We talked about how there have been 2 DRB reviews of the vegetation at my property. The first one in 2012 said the side trees and the trees in our backyard could be a blanket of 20 feet. The second DR last year, which is what we're appealing today, I don't think did anything outlandish. They basically they continued that 20-foot blanket statement and added a buffer and a cutting schedule. That buffer of 5 feet was added because the Schiffmans were in contact with code enforcement 96 times from February 23rd to May 24th. This is my Freedom of Information packet. They also gave a trimming schedule of twice a year, which protects the Schiffmans so that we actually do the trimming. So I think they actually were trying to factor in everyone's interests. They also found that the Schiffmans did not have a view equity issue with respect to Catalina. Their house isn't oriented towards Catalina. They have a sweeping, beautiful primary view of the ocean in front of them and an oblique Catalina view through our property and properties below on the hill. If you give them this oblique view through our property, we're basically they're going to insist on cutting even more trees of our downhill neighbors than they already have. And you're going to have more versions of this hearing for the downhill neighbors who have the resources to fight back, or they'll suffer financial and emotional hardship solely to give someone an oblique view of Catalina when they have an enviable sweeping view in front of them. So I ask you to uphold the DRB finding of 2025, because I think they did their best to balance everyone's interests, including the downhill neighbors, including us, and including the Schiffmans in terms of cutting schedule. If you do feel like you have to change the DRB's ruling, I ask you to keep it extremely simple. All of these cuts like this and steps like that, we have been neighbors of the Schiffmans for long enough. They're hyper picky and hyper litigious, and I don't want to be in code enforcement all the time for this. So keep it simple, please. Give us a height, give us a buffer. But I think, honestly, the DRB finding was the right one for everyone involved. Thank you.
Thank you. Any other speakers?
Good afternoon. My name is Spencer Harrison. My wife Melanie and I are the owners of 1765 Temple Hills Drive, which is 2 doors down from Matt and Kavita and 3 doors down from the Schiffmans. We are here in support of the Matt and Kavita's position in this matter and believe that the DRB arrived at a fair and correct solution here. My point, I will try to be brief. My point is this is the tip of the iceberg. We've had 2 run-ins with the Schiffmans thus far. The first was before the Design Review Board some years ago when we did a remodel. The Schiffmans petitioned to have us remove 5 palm trees along the property line. And, you know, we thought it was ridiculous. They have a fabulous ocean view. And their argument was that if you go out on the terrace and you turn to the right, that there is Catalina behind our trees. And the problem with that argument was that behind our trees are a whole cliffside of additional trees. And, you know, when this was pointed out to Dr. Schiffman, he said that he told my wife that once he gets our trees down, he'll go after the neighbors to get all of their trees down. And he repeated that at the Design Review Board. This has got to stop. This is harassment. And, you know, fast forward to last fall, we cut down the 5 palm trees. Fast forward to last fall, he filed a complaint with the enforcement group claiming that we had not complied with the DRB agreement to remove the 5 trees. City enforcement issued a notice of violation, and I was absolutely outraged. I had enforcement come over, and they finally backed down when I showed them the stumps of the 5 palm trees that we had cut down. In any event, his mission is for us to cut an additional 3 palm trees down. And we're just not going to have it. We're not going to have it. I urge you to support the Design Review Board decision here and do what you can to bring an end to this harassment of the Reddys, of us, of a bunch of other of our neighbors. This isn't going to stop until somebody puts their foot down. Thank you for your time.
Thank you. Any other speakers in opposition to the appeal?
Hello, council members. Nicole Anderson. I live at 1701. And I have also had interactions with the Dr. and Mrs. Schiffman starting in 2023, where I have a series of emails, including this, which I'd like to show, where this was after our trees were trimmed, where he wasn't happy with this very few branch. We had to get the tree trimmers back. My point is when is this going to stop? I had some, which I kept all the interactions very pleasant, but he basically threatened that if I didn't cut this tree, he was going to take me on a view restoration process. And he also got quoted that he's been in extensive disagreements with my neighbor, Robin and John Walker, who are here today, where she finally had an epiphany after she lost a review on her sycamore tree. And they have an incredible view. We all have incredible views. I just don't know how much is enough for them. It is never enough. The fact that my sycamore needed to be trimmed so that they would have, you know, an inch more of horizon, I agreed to it. But he kept threatening that we're going to have to do this every year and we're going to have to come on an agreement of how much is enough. So I also asked that you would uphold the 2025 decision that you made, because it just, to me, is not a neighborly thing to have to do. I'm happy to keep my trees trimmed to a reasonable amount. And if you do have to decide something, I'd like to know what that amount is so I don't have to go back and forth on these emails with him. And I'd like to know where that level has to be. But the fact is he does harass all of us and he threatens us. And I'm happy to share these emails. And I feel the most poorly for my neighbor, Robin. So hopefully she'll get up and talk too. Thank you.
Thank you. Any other speakers in opposition to the appeal?
Hello. My name is Robin Donegan Walker. I've been a Laguna resident since 1963, and our family has owned and lived at 1715 Temple Hills Drive since 1965, so we're a few houses down. We are stewards to a 100-year-old native sycamore tree that last of a stand of 8 sycamore trees, planted long before any of our time. This last healthy mature tree grows approximately 490 feet below 1843 Temple Hills Drive. So we have endured similar hearings and actions brought by Mr. and Mrs. Schiffman, costing us to date over $10,000. I am here today as a Temple Hills community member to support Kavita and Matt and to ask you 3 questions. Number 1, can you tell us how many cases on the view of 1843 Temple Hills Drive have been brought before the city and the city committees in the last 10 years? Number 2, do you have data to share on city staff time and budget expense spent for code enforcement and complaints lodged from 1843? And lastly, outside of official channels, as Nicole referenced, do you know the number of other property owners in our neighborhood approached privately by Mr. and Mrs. Schiffman about cutting down their trees in the Temple Hills area? Thank you.
Thank you. Any other speakers?
Good afternoon, Mayor Orgill and council members and staff. Happy New Year. We were trying to avoid having this hearing today, and I know that both sides worked very earnestly, both attorneys, and we didn't quite get there. I kept promising the staff, we're almost there, didn't quite get there. But I'm up here today just for some clarification. The reason why the Design Review Board gave us that 5-foot buffer was to allow time to trim the plants. What happened during this process, there was a complaint filed, code enforcement came out, and the code enforcement officer fined us because we were 6 inches too high, about the length of a leaf. And that was pretty outstanding. The board decided they needed to give the applicant some leeway. I know that Bob has some concerns that 5 feet might be too much. We're willing to accept 2.5 feet as was marked. And we're also, just for clarification, we want to put in permanent poles that are similar to what you see with the wood, but they would be much more discreet. They would be narrower, probably a 1/2-inch copper tube embedded in concrete and at 20 feet above the measured height from the code enforcement officer. So the lovely thing about the copper is that it will patina to a green and it'll disappear into the hedge. So we're willing to do that at the applicant's expense as well. Thank you.
Thank you. Any other speakers in opposition to the appeal? If none, then we'll move on to appellant rebuttal, 2 minutes.
Hi, thank you. Thank you, Mayor, members of the council. Daniel Friedman, I'm going to present on behalf of the applicant, appellant, I should say, just because a lot to cover, a very short amount of time. First off, I'd like to just address, I think the presentation that has been brought before you is very deceptive by the applicant. First off, you do not need property owner authorization to file an appeal. You can be a tenant, you can be someone who lives there. The whole concept that their application is valid and that its appeal is invalid is totally incorrect. The application, in theory, should not have ever been heard because it was not processed or submitted by the owner of their property. You do not need to be a property owner to file an appeal. With respect to the slide that was presented to you, I think that perfectly encapsulate the problem here. There was an image taken from the corner of the second story of their home, and they said, this is the angle that you get all your views. Meanwhile, the Schiffmans, my Schiffmans neighbors, they get privacy from every angle, and the Schiffmans get a view from one corner of their second story. That's the deception that's happening here. If you go to the Schiffmans' first floor, it looks like you're in a jungle. There is a giant, massive hedge. And when Mr. Kavita, their landscape consultant just spoke, he said, oh, it was 6 inches. It wasn't 6 inches. There's 2 trees that were never supposed to be there. Plus, it was much higher than it was ever supposed to be. The Schiffmans aren't bad people. It's the city's policy to maximize views. That's what's in the city's general plan. It is the property owner's obligation to take basic efforts to protect those views on behalf of their neighbors. That's what we're asking for. We're asking for the city to use, and this council to use reasoned judgment to see what is appropriate for a hedge like this. Thank you for your time.
Thank
Please,
you.
we ask that you please grant the appeal and consider 15 feet. Thank you.
Thank you. Does staff have any response to the appellant? None?
Thank you, Mayor. I might make a few comments. Shweta, if you could pull up the hedge height slide, please. And while Shweta is navigating to that slide, I will mention that city staff did speak to the city's landscape plan checker, who reviewed the landscape plans before the application was deemed complete and scheduled for a hearing before the design review board. I'll start by saying our landscape plan reviewer does a really exceptional job with his reviews. He's an expert in his area of expertise. I will say that he does not administer the city's hedge height claim process. City staff explained that landscape plan modifications are subject to design review approval when it's a modification to a design review approved plan. And we also cited the relevant code section, and it is my belief that we are on the same page. Now, regarding the appellant's assertion that the application should have been processed with the city's hedge height claim procedures. Again, once a landscape plan is approved through design review, any future modifications to that design review approved plan requires design review approval unless specifically exempted by the city's municipal code. Here, there is a code section that states that modifications to prior DR approvals do require landscape design review board approval unless exempted. Staff has reviewed that list of exemptions and none apply here. Furthermore, the city's hedge height claim procedures in the municipal code state that hedges and vegetation authorized as part of an approved landscape plan for which a maximum height has been established through design review are not subject to the hedge height claim provisions. And that is what this design review application before you will do. Finally, some of the unpermitted vegetation being potentially legalized through this application would not even be eligible for a hedge height claim, even if we put aside that design review process, which again is required, because some of the vegetation that is part of the landscape plan modification is not located within a front, side, or rear yard setback, which is required to go through that hedge height claim process. Lastly, I will mention that there is a design review trigger for hedges located within a front, side, or rear yard that is proposed to exceed the maximum allowable fence height as here. And the View Restoration Committee cannot serve as a decision-making authority on a design review application.
Thank you. Does council have any questions of the appellant, applicant, public, and/or staff? None? Okay. Then we'll close public testimony and bring it back to council for comments and deliberations.
As was alluded to in some of the testimony, I think one of our options is to uphold the decision of the DRB, but include more restrictive conditions. I think you can, and the applicant has, I think, generously offered to lower the 25 feet. I think the 25 feet is too high. I mean, you can argue that they've got a great view and all that, but there's no reason for 25 feet to preserve the privacy of the applicant, which I think is something that should be preserved. But I would think I would be supportive of reducing it down to, something of a range between like 19 and 22.
So that would be in line with the document that Larry showed with the 2 yellow lines?
Yeah, I think so. And I liked Steve's idea of putting in
Stakes.
poles that would permanently mark the height.
Okay, great. Thank you. Any other council comments? Sue?
Yeah, I do. So I visited the applicant's property and the appellant's property. And after I went to the property, I read the staff report again, and then I watched the hearing, the design review board hearing of February 13th, 2025. And then as I was going through the video, I was looking at the contentions by the appellant. And, I walked through each one of these pretty carefully, but I don't see really any, we do these all the time. Sometimes you can find abuse of discretion. It's not all that common, but I didn't find any abuse of discretion here. There's some allegations and stuff that probably are not necessarily proper for an appeal, my personal opinion, but I didn't see any abuse of discretion there, which is kind of the basis of our, determination of how we handle these things. I do think that, so I would vote to uphold the design review determination, and I would give them 2.5 feet, because I do want to eliminate this leaf sticking up business and having, it's not worth it to have code enforcement run out there all the time. So if we have a 2.5 foot buffer, I think that's fair. I think the house itself, the Schiffman's house, has a huge view. And yeah, it's true, you have to turn to your right to see it, but you can still see Catalina, and I could see it clearly. My own personal house, I have a big view too, but I can't see Main Beach because someone has vegetation there. That's life. That's the way I see it. I just want to make a comment that, I wish everyone could calm down, because the idea of view equity doesn't mean you get your whole big view, any view you could possibly get. It means you get a view that makes sense from a perspective of a design review board or by law maybe. But I don't, I want to eliminate this. The idea of the view equity, the view preservation and the view ordinance that we have is not to clear hillsides for views. It's really the way it came about was, a lot of people had blocked views because they used to have a view and now they don't, because somebody moved in, some person got old, stopped taking care of their trees, somebody lived out of town. There was a lot of that, but it was all primarily in your immediate vicinity, and I'm talking immediate. So that was the intent of it, and really to keep things trimmed up. So I hope this doesn't become a situation where people are just getting really unnerved by each other and going after each other, because that doesn't make for a good it doesn't make for a good situation from neighbor point of view. And so those are my comments.
Hallie?
I think what my fellow council members have said makes a lot of sense. I don't see any signs of indiscretion or inappropriate decision-making by design review. I appreciate, and I think it makes sense to compromise with a 2.5 foot buffer. I think that buffer is really important. We all know vegetation can grow unpredictably, so I think that's reasonable. And I would support a 20 to, let's say, 22.5 limit. And I think that the poles will hopefully go a long way in preventing future issues. We're all neighbors. We all run into each other at the grocery store. So my hope is everybody can put this behind them.
Thank you. Alex?
Yeah, so I mean, I didn't get a chance to visit the site, either the applicant or the appellant, but I think that, today we're here in a quasi-judicial function, right, where it's really not our role to express our policy preferences. It's not a de novo hearing either, so it's not our place to make the determination on its own about view equity. I think the question before us is whether any of the contentions raised in the appeal show that there's an abuse of discretion. And the appeal number 7 related to view equity is about the idea that there was not substantial evidence to support the contention that there was good cause to approve a substantial modification of a landscaping plan. Question for legal counsel, just to confirm, our code is, the applicant doesn't have the burden to show why they need to deviate from the previous plan. The question before the board was whether there was substantial evidence that the project before it complied with the code and view equity. Is that a fair characterization?
That is correct.
So then I think, based on that, and I respect, everyone involved. I respect Mr. Schiffman's service on the view equity committee. But I think based on, what our role is here and based on the appeal and based on the evidence in the record, I don't see an abuse of discretion, and I'm willing to support the compromise that the applicant is willing to agree to.
So with that said, council does have the ability to make an adjustment, even
Correct,
if
Mr.
we
Mayor.
find that there was no.
Correct. If hearing the applicant, agree to it, all parties are in agreement, that's entirely appropriate.
Okay. Well, I agree with my other council members, and especially with the comments that Sue had made is regarding, the neighbors and, being civil with one another. And I think Bob's recommendation with the 2.5 feet not to exceed after pruning makes sense. So it'd be 20 feet with a 2.5 feet buffer for allow for times during trimming. And I guess the applicant had said that they would be open to trimming of 2 times a year. And that combined with the copper stakes, if they're willing to do so, then I would be supportive of that. So any other comments? Okay, then we will close the public hearing and develop a motion here. Do I have anybody who'd like to make a motion?
So I think under option 2, we'd adopt the resolution upholding the decision of the board, and but including modifications with more restrictive conditions to limit the range between 20 feet above grade and 22.5 feet, with trimming twice a year, and the installation of the copper stakes that would mark the top end of the range.
Second.
All in favor?
Aye.
Opposed? Okay, it passes unanimously. Thank you, everybody. We'll move on to appeal number B, 1550 Bluebird Canyon Drive. Does council need a break? Anybody? You okay, everybody? Bob, Hallie? Okay, then all right, we'll take a 3-minute break. Appeal B, 1550 Bluebird Canyon Drive.
All right.
Any disclosures, first of all?
I met with David Jernais and Horace Knoppenberger, and I met with Susan and Harp Hall.
I met with the same individuals.
I met with the same individuals as well as the applicant's legal counsel, Morgan Gallagher, and Mark Orgill was also in that meeting.
Correct. And I've met with Horace and Mr. Daenerys as well. So, great. Okay, we'll open the public hearing.
This time around, I just
I'm
met
sorry.
with Susan Wetton and Harpal.
Thank you. Open the public hearing and ask staff for their presentation.
Thank you, Mayor Orgel and fellow council members. This is Appeal B, 1550 Bluebird Canyon Drive. There are two entitlements involved. There's a coastal development permit and a design review. The project is located in Bluebird Canyon neighborhood and is a vacant site zoned R1 residential low density on what is known as the knoll of Bluebird Canyon, featuring steep upsloping topography at Bluebird Canyon Drive before leveling out at the top of the knoll. The property was previously subdivided pursuant to an SB 9 lot split, which created 1550 and 1560 Bluebird Canyon Drive. The final map has been recorded, effectuating the subdivision. The proposed project is a new single-family home and two-car garage. There is no ADU proposed. Staff's presentation will go over the background, contentions, CEQA, standards of review, city council options, and staff's recommendation. A bit of the background with the design review board was that the board reviewed the project 3 times. On the 3rd hearing, the board denied the project and the applicant submitted an appeal on that denial. I'll turn it over to Assistant City Attorney Jane.
Thank you. So contention number 1 in appellant's notice of appeal is that the board relied on subjective standards to deny the second revised project in violation of SB 450 and the Housing Accountability Act. Staff confirmed in the November 13th staff reports that the projects are consistent with all LCP policies and all objective design standards. Therefore, under SB 450 and the Housing Accountability Act, the board did not have authority to deny the projects. Next slide. So in response to appellant's first contention, we will start off with an analysis of the Housing Accountability Act. The Housing Accountability Act applies to residential units, plural. And when it is triggered, the city is required to provide a written letter of inconsistency with various standards within 30 days of completeness. That is when the application has all documents that are required. Additionally, when the Housing Accountability Act is triggered, the city must make specific findings to deny or reduce densities for a project. Here, the Housing Accountability Act does not apply. This project consists of 1 residential units. In fact, a case cited 79 CalApp 5th 1016 has held that it does not apply to 1 residential unit. Here, the original project was submitted without an ADU. The revised project was submitted without an ADU or a second unit. The second revised project, while the applicant did attempt to add into an ADU, and this is discussed later in response to contention number 5, the applicant did not consent to processing the required variance for the ADU and did not pay the fees or fill out the application for the CDP and variance triggered by the added ADU. City staff offered to delay the project consisting of the single-family residence to process the variance and the CDP for the ADU, but the applicant decided to move forward with the single-family residence project at 1550 Bluebird Canyon, which was being considered by the DRB so that it could coincide with 1560 Bluebird Canyon Drive, which was also being considered by the DRB. Accordingly, the plans for the ADU are not part of the second revised project and did not create a second unit to be considered by the board and therefore did not trigger the HAA. The ADU has not been properly noticed and also cannot be considered by the City Council. In conclusion, there is no written requirement for inconsistency letter, and there's no requirement that the city make any specific adverse impact findings under the HAA if denying or reducing the square footage or density of the project. Next slide. With respect to SB 9 and SB 450, this is a state housing law that allows ministerial 2-unit development projects under certain qualifying conditions. With SB 450, the Coastal Act still applies, so it does not modify or alter or supersede the California Coastal Act, except for a public hearing requirement. This is discussed in the case Canal Gardens versus City of LA. Based on this, city staff's conclusion is that the discretionary CDP standards are required by SB 450 and under the ADU statutes under the California Coastal Act. The City Council previously directed the Design Review Board in another similar case at 1560 to disregard design review requirements in conflict with SB 450 for a qualifying project based on the City Council's finding that the coastal development permit findings and criteria adequately protect coastal resources. So therefore, DRB was required to consider all discretionary CDP findings and to consider the subjective DR criteria only to the extent to protect coastal resources not otherwise protected by the CDP findings. The remaining questions for the City Council on this appeal with respect to DR would be, do you find that the discretionary CDP findings adequately protect all coastal resources under the Coastal Act, such that applying discretionary DR is duplicative or unnecessary? The second question, which relates to the CDP, is what substantial evidence, if any, supports DRB's findings for coastal development permit finding 1, criteria 5, which is quoted as the proposed development will minimize the alteration of natural landforms and will not result in undue risk from geological and erosional forces and/or flood and fire hazards. The third question relating to the CDP is what substantial evidence, if any, supports DRB's findings for coastal development permit finding 1, criteria number 6, which is quoted as the proposed development will be visually compatible with the character of surrounding areas and where feasible will restore and enhance visual quality in visually degraded areas. Next slide. In SB 450, there are certain qualifying conditions as alluded to on the previous page. One of those qualifying conditions relates to the very high fire hazard severity zone. And projects will be disqualified from the very high fire hazard severity zone unless they are on sites that have adopted fire hazard mitigation measures pursuant to existing building standards or state fire mitigation measures applicable to the development. Next slide. Here, the city adopts the California Fire Code by reference in its municipal code. The fire marshal and building official have reviewed and approved the alternative materials and methods of construction prepared by Dudek for the property. And it's dated September 24th, 2024, as well as prepared and approved the alternative materials and methods of construction prepared by the fire marshal and building official dated today's date relating to firefighter access road width and firefighter access path. That memorandum has been posted online and is circulated at this meeting if members of the public would like a copy, and has been passed out to the City Council. In short, what an alternative materials and method of construction allows is the fire official to deviate from the fire code when making a finding that the alternative is just as effective in fire safety. So the Dudek report analyzes certain fire code requirements that have not been met and makes certain findings as to why those alternative measures meet those requirements substantively. And I have here the fire marshal and building official to walk through the Dudek report and also the more recent memorandum relating to the fire access road and width and fire access path. So I'll turn it over to them.
Good evening, Council. Gabriel Linares, Deputy Director of Community Development. The projects were reviewed and they shall comply with the residential fire standards for construction, landscaping, and on-site fuel modifications, except for 3 areas that have been remediated via alternate materials design method approvals. Dudek Consultants have submitted an A&M report that provided remedies for the 3 areas in question. The 3 areas are 1, 150-foot hose pull requirement. 2 would be the fire apparatus road width. 3, the firefighter access 3-foot path of travel. And I have the Fire Marshal Robert Montaghi here to go over those conditions of approval for those items.
Good evening, Mr. Mayor, members of the council. Thank you for the opportunity to speak for you and make comments on this project. Robert Montaghi, your Fire Marshal. There were 3 elements in this project that I did review to ensure that it meets the fire safety standards due to the very high fire hazard severity zone where this project is located. And the 3 elements basically are 1, the 150-foot hose pull. This is pursuant to California Fire Code Section 503, 1.1 respectively, where it basically states that the most remote area of a building shall be within 150 feet of a fire apparatus itself. 150 feet, that is the path where a firefighter would take to access the most remote area to fight a fire within the structure. And one of the alternative means and methods provided, which is a normal process that we go through, similar to a lot of other projects that we do consider similar to this condition, where the remote area of a building is not within 150 feet. And the normal process is that they do submit alternative means by installing, providing wet standpipes that a firefighter can access and connect to and provide a water supply to fight a structure fire. So this is a very typical and normal routine that is submitted as an alternative means and method for in lieu of that 150-foot access. And the second element that I looked at within this project is the fire apparatus access road width. It didn't specifically address it, but it did in some ways in the plan itself. And that is in pursuant to Section 503.2 of the Fire Code, where a fire apparatus access road shall be shall have a minimum width of 20 feet. And 3 considerations that I had that I reviewed and considered when providing the alternative means for this area of the code is, one is that the Bluebird itself road is a throwaway and has multiple access routes. And it functions as a thorough street and is not a dead-end roadway. And the fire apparatus would maintain a continuous access and maneuvering capabilities throughout the area via multiple intervening streets. And as such, emergency vehicles would not be dependent on a single point of ingress and egress, thereby reducing operational risk normally that would be associated with reduced roadway width. And the second point was that our fire apparatus capability within City of Laguna Beach, our apparatuses we operate are a shorter wheelbase and the fire apparatus specifically, which are suited for the city's narrow hillsides roadways. And then the vehicles, therefore, are capable effectively navigating these roads, specifically at Bluebird Canyon Road. And the third aspect was the parking restrictions that was addressed in the plan itself. And that is for there was the portion where no parking fire lane that we require, because the parking there is restricted. In other words, on-street parking is not allowed. And this was addressed somewhat in the plan itself. And there are conditions that we are approving that as well that would meet the third element that I considered for the road width, that there would be no future parking allowed other than what was stated, approved on the plan itself, that are designed as part of this construction and was submitted under the plan. And that does not impede into the roadway. And any future modifications to roadway, of course, would have to be approved by the fire department as well. So considering all that, take into consideration the issue with the section 503.2 for the road width does comply. And the third thing was the element in this was the firefighter access path. The city of Laguna Beach does require a minimum 3-foot wide all-weather non-combustible firefighter access path that should be provided around the structures with access to all emergency escapes and rescue openings, of course. And the proposed plan requested an alternative means and methods that would allow a shared common firefighter access path between the two residences, which does not strictly comply with the city's requirement for independent access path based on the site condition. However, operational considerations and compensation for safety features associated with this project, the fire department will accept the proposed shared firefighter access path with the following, of course, findings and conditions. And three findings. The shared firefighter pathway, which we reviewed, it provides access to both properties, and it does connect to the both structures. However, there are some conditions we are requesting for that as well to be maintained. And the location and configuration of the path, of course, provides a practical access to both. So the provision of the fire resistive construction further assists us, or allows us to provide for this alternative means and method as well. And of course, with considerations or with subject conditions such as allowing a shared common fighter path to be maintained and obstructed with all-weather and non-combustible path to be maintained perpetuity for these two properties. And any future fence or any wall or anything obstructions would have to be approved and reviewed by the fire department first to ensure that it doesn't impede on our access. And let's see here, any modification to the shared firefighter access configurations, of course, again, would have to be approved. So based on all these considerations, the fire department has approved the alternative means and methods to address all the fire safety elements for these two projects. And that is the conclusion of my area of presentation. I'm available for any questions you may have.
One question I have. So the roadway width varies between 18 and 20, as you state in your report. With the two proposed on-site, on-street parking, what's the width there if there are cars parked there?
The lowest point would be 18 and a half feet, the lowest point.
With the car parked?
Correct.
Okay, thank you.
Has staff concluded their
We'll
presentation?
continue on the other contention. So the second contention is that the board improperly cited replacement of the SCE pole in front of the applicant's property to allege a fire hazard when the applicant has no control over SCE's replacement of the SCE pole. And there is no evidence in the record that replacement of the SCE pole will cause a fire hazard. In response, staff agrees there is no evidence that the SCE power poles create a fire hazard. The poles are located in an urbanized area along an existing street. The poles are being replaced as part of an SCE fire safety upgrade project. Even if reliance on the utility poles was improper, the board may have cited other independent grounds supporting denial. Any reference to SCE power poles as a basis for denial would therefore constitute harmless error. And contention 3, the board incorrectly alleged that the natural profile of the property is a coastal resource. The board's position is inconsistent with state law and the city's own documents. There are no public viewpoint or environmentally sensitive areas on the property as confirmed by the city staff in the November 13th staff reports. In terms of coastal zone applicability, although approximately 1 mile from the ocean and not in an ESHA, the site is within the coastal zone and subject to the Coastal Act. Discretionary CDP standards are required by the HAA, Housing Accountability Act, and the SB 450 under California Coastal Act. The CDP finding number 1, criteria number 5, which is related to the natural landforms alterations, applies. Hillsides and coastal resources, the city has been consistent treating undeveloped hillsides as coastal resources. The LCP open space and conservation element defines hillside visual resources as protected coastal scenic resources. the design review board's determination was that the long sloping driveway, hilltop siding, and retaining walls significantly alter the natural landform and that the project was not designed to minimize landform alteration. Staff's assessment of the landform is that limited grading likely occurred pre-1938 for the water tank access road that later disappeared. The extent of the grading is unclear. Large portions appear ungraded. The applicant's assessment of the landform is that the knoll is not a natural landform, asserting that it was graded prior to 1940 based on a topographic survey. The applicants provided a letter from a geotechnical consultant today regarding the non-natural state of the landform. And the questions that council would be asking is what substantial evidence, if any, support DRB's finding related to CDP finding criteria 5, which is related to minimizing alterations to natural landforms? And is the knoll a natural landform? If so, does the project minimize its alteration? And contention 4, Jane?
Thank you. Appellant's contention number 4 is that the board alleged the projects were inconsistent with land use policies, including land use policies 7.3 and 10.2, well after the city was required to inform the applicant of any project inconsistency with applicable policies pursuant to the Housing Accountability Act. Next slide. The Housing Accountability Act applies to residential units, plural, and requires an inconsistency letter within 30 days of completeness. The Housing Accountability Act does not apply here. Therefore, the city was not subject to a requirement for a written inconsistency letter. Contention number 5. And contention number 5, the board improperly excluded the accessory dwelling unit that was added to Lot A on September 24th from their consideration on the CDP for Lot A. The ADU does not change any facts in the staff reports and does not require a variance. The applicant is specifically appealing the ADU to the city council as part of the present appeal. City staff's response to contention 5 addresses the state ADU law, which has the exact same Coastal Act savings clause as SB 450. The state ADU law does not modify the California Coastal Act. In accordance with this state law, the city has adopted regulations governing the approval of ADUs in its certified LCP in Chapter 2517. The city also has an urgency ordinance 1713 that applies to this project. In accordance with that ordinance, ADUs are subject to the CDP requirement and require compliance with the applicable certified LCP provisions. ADUs are exempt from design review requirements. Here, the applicant submitted plan sheets with an ADU that ultimately conflicted with certain applicable requirements in the city's certified LCP. Because the applicant did not submit a formal application or pay the required fees, city staff did not do a detailed review of the plan sheets for the ADU, but did identify this inconsistency upon a brief review. Applicant disagreed with city staff's identification of an inconsistency with any open space landscape requirement that applies as part of the city's certified LCP. As such, the applicant did not consent to the city processing the variance, and therefore the ADU was not a part of the second revised project. Before the city council tonight is the second revised project, which consists of the single family residence. It has not been noticed for a variance or a CDP on the additional ADU, and therefore it is not before the city council's consideration this evening.
For CEQA, the decision to uphold the denial is exempt. If the appeal is sustained, determine if the project is exempt from section 15303. Oops. And to go over the standards of review, briefly, these are the standards of review for design review. we can come back to it. It's just a refresher, as well as the standards of review for non-design review decisions. And here's the definition of abusive discretion. City Council's options are to adopt the attached resolution upholding the denial and finding CEQA does not apply to the denial of the project under state CEQA guidelines, section 15270, or adopt the attached resolution granting the appeal and overturning the board denial with findings in support of overturning the second board denial and approving the second revised project subject to conditions of approval. Staff's recommendation is to conduct a public hearing, including receiving a staff report and taking public testimony and all evidence relating to the consideration of the coastal development permit and design review and California and CEQA. Following deliberation, take action to either adopt a resolution upholding the decision of the design review board to deny the project, which is option A, or adopt a resolution as amended, granting the appeal and overturning the design review board's denial of the project, which is option B. That concludes staff's presentation.
Thank you. Are there any questions of staff from council?
So I just want to be clear on the standard of review. So what we're reviewing here is the denial by the DRB of the project based on its inability to make the appropriate findings for the coastal development permit. And these are the non-review decisions. There's no design review based decision that we need to address here tonight because their finding was purely on the CDP side, correct?
That's correct.
Okay. So then we can consider evidence presented here. I haven't seen it yet, but I heard today there was another letter that came in from a geologist on this natural landform. It's hard to review stuff that comes in the day of the hearing, but we can consider anything that's including that and other things that are presented here at this hearing that were not, or prior to this hearing that were not presented to the DRB.
Yes.
Okay. Thank you.
Thanks for the clarification. Any other?
So can I ask
Yeah, Alex.
So just to be clear, so for purposes of the kind of the rules of the game here, SB 450 and the HAA both require objective standards, but then there's an exception, there's a carve out for the Coastal Act in which we can apply subjective standards for purposes of complying with the Chapter 3 policies of the Coastal Act.
Correct.
And the key distinction is that there's no inconsistency determination requirement for purposes of telling the applicant, whether they comply with all the policies, whether they're objective or subjective, like there would be under a Housing Accountability Act project.
Correct. Here, the HAA does not apply because there's only one unit, so that requirement
The
is not.
inconsistency determination.
Yes.
So then we go to the chapter to the Coastal Act savings clause, and coastal resources are inherently subjective.
Correct.
Right. And there is carve outs. State law has the legislature knows how to create objective coastal determinations. For example, like there's, I think, SB 35, right, that has objective CDP findings.
That's exactly
That's not the
right.
case here. It's subjective.
Correct.
And then, so then now the question before us is about making the findings under our coastal development permit, right, based on our LCP. And so our whole city's code is in the LCP, right? So we're not, for purposes of this, it sounds like staff's determination is that, design review doesn't apply, even though that's technically part of our LCP. It only applies to, our LCP and our CDP findings only apply to the extent that Chapter 3 policies of the Coastal Act would apply.
Correct. City staff would recommend applying the Coastal Act and those Chapter 3 policies when considering the project.
Okay, those are my questions for now. I'll have more after public comment. Thank you.
Any other questions? Hallie, no? Great. We'll open public testimony, starting with the applicant appellant and allowing 5 minutes for a presentation.
Good evening, Mayor Orgel City Council members, I'm Horst Knoppenberger. I'm the project architect on this project. Can we have our, thank you. So we started this project. What I want to do is kind of give everybody kind of a glimpse of the arc of the project and how the project transformed, based upon, feedback that we got from the neighborhood and feedback that we received from the design review board members, along the journey. First thing we did is we met with the neighbors. There must have been 20 neighbors at that first site meeting, even before putting pencil to paper on the design, and we listened to the neighbors very carefully. I felt like we understood, what their goals and desires were, and then we began to kind of flesh out a building. And the approach was to create a building that was in harmony with, the character of Bluebird Canyon. Having lived in Laguna myself for 35 years, Bluebird Canyon is a very distinctive place that is, really important to the sense of community. And as the design evolved, it became a very minimalist composition of two pavilions, which, overlap each other. As you can see, in the rendering, the materiality of the project reflects a rustic, palette of materials that helps the building to dissolve into the natural landscape. There was another design for the site from another architectural firm, that David was working with. And some of the changes that we made is we pushed the entry back further so that there would be a large landscape buffer space between our proposed project and the neighbors who live below us on Bluebird Canyon. The other move that we made is I met with Susan Witten, who I've known for many years. Her son was an intern in my office. I wanted to create something that would be very compatible with Susan and the property that she's enjoyed for many years. So the pavilion to the left, the single-story pavilion above the garage, reflects the single-story composition of Susan's house in a very, I feel, harmonious way. Next slide, please. And now I'm just going to review quickly some of the changes that we made. At the second design review hearing, based upon comments that we received from neighbors and city council members and design review board members, there's an approximate 10-foot wide easement, and the easement is the distance from the existing street paving to the property line. And we were directed to, create a situation in which if the city ever wanted to take over the entire 10-foot easement, it wouldn't throw our project into a non-conforming condition, for example. So we revised the driveway, we revised the retaining walls, eliminated retaining walls, to address that. And at the time when we did that, it was my clear understanding that the two board members who were in clear opposition to the project, Louis Wheel and Tom Gibbs, that was, at least in my mind, the last remaining issue that we needed to address. And I feel that we addressed it very effectively. Next slide, please. This is a view of the project, let's say from Susan Witten's property, looking back at the single-story pavilion. The project was sited in a way that the finished floor of our great room, which is that lower level single-story pavilion, the floor is approximately 3 foot 6 inches below the top of Susan's roof, so that we, from a standing position, we could have some view over the ocean, over Susan's house. And then we pushed back the second pavilion, which rotates over that base pavilion, so that as Susan looks up from her property, the appearance of mass and scale is mitigated by the staggering of the volumes. And this particular strategy is very resonant with the requirements, the objectives of the Hillside Design Guidelines. I just wanted to say, as an aside, this project won a National Design Award with the American Institute of Architects, and we're very proud of this project. And we feel that it will be a very positive contribution to the neighborhood. Next slide, please. Next slide. Next slide. Thank you. We did look at, with an open mind, the idea, my understanding, the neighbors wanted us to put a 3-car garage at street level, so we looked at it. It creates 500 cubic yards of additional excavation. It creates a very unsafe condition. As you back out of the garage, you've got 13-foot high retaining walls on both sides. So we abandoned that idea. Next slide. And here's a section, shows the garage. Maybe 30 seconds. Is that possible? Just
Pardon me, yes.
Thank you,
30
Sam. I'll go very fast. Next diagram, please. We also looked at the idea that the driveway on the left is what we've designed, a driveway that's very similar to the driveway that the Witt property currently enjoys. That was, built I think 80 years ago. You start at the high end of the street and you work up. You traverse the topography diagonally, and you get to where your garage is. But we also looked at the alternative driveway on the right, where we start at the low end of the street and we move away from Susan's property. But because of the topography increasing at the right end, the east end of the site, we're 20 feet below grade, so it didn't work. But we looked at it with an open mind. Next slide. I think this is my last one. Next slide. This diagram represents that 70% of the buildable area of the property in yellow lies above the top of the slope. And, because of that, it makes perfect sense to build this house at the top of the slope, much like Susan's house was built and designed 80 years ago. It made sense 80 years ago. It makes even more sense today. I think that's it. Maybe one more slide. Yes, that is it. Well, just quickly, in terms of pattern of development, our floor area ratio that we're proposing, and that's the ratio between habitable floor area and lot size, is 37%. Of the 16 adjacent properties that we surveyed using a variety of city records and tax records, the average floor area ratio is 40%. So we're certainly within the pattern of development in terms of the floor area, mass and scale, et cetera, et cetera. Thanks.
Mayor, can I ask Horst a question?
Sure.
Horst, question, just a couple. What's the square footage of the lot? I should know that, but I can't remember.
12,360.
Okay. And just another question. I know you showed from, the view from the orientation view from Susan Whiten's property, but if I'm standing on the street, what will I see?
Yeah, that's a great question. So as you're standing on the street, we wanted to preserve as much of the natural topography as possible. And so what we did is we pushed the house back from Bluebird Canyon. So what you're presented with in terms of the foreground is this large courtyard with these three Palo Verde trees within the courtyard. The other thing that you see is our retaining walls. Like we saw in my office today, they're concrete crib walls that allow for planting in between the crib walls. The neighbors were objecting, rightfully so, of the height of these retaining walls for the driveway, so we changed those walls to crib walls. There is an image of that. I can get a little bit further in the, maybe just a couple images back. Yeah, Mary. The next one, please. Next one. Next one. I know it's here somewhere. The lower right-hand corner, this is an image very similar to the crib wall construction that really works beautifully at Heisler Park. It allows plants to grow in between these cells so that eventually these retaining walls, and we only have one retaining wall on our project, become like a natural extension. So long answer to a simple question, Susan, but what we hope that people will see is the natural topography, the vegetation, and then the house would recede. That was the idea behind the minimalism, allowing the house to kind of harmonize with the landscape through restraint and simplicity.
Okay, thank you.
Thank you.
Horst, a couple just other quick questions just to get some factual things clarified. So height above the ridge line, how much do you protrude?
Great question. So what we have to work with is we have a height limit that is 15 feet above existing grade along the rear property line. So on average, we're about 12 feet. In some cases, in some places, we are 15 feet. My understanding of the Culver House that the City Council approved, they also have the same constraint. That property line is their rear property line. They're about 13 or 14 feet. So we're sort of comparable to what they were approved for. Thanks for that question.
And then the other question is, when you look at the overall the area of the lot, I guess Sue just asked, it's 12,600 and something square feet. What percentage of that ends up being graded as a result of this project?
Ooh, that, I don't have an exact number on that. Well, yeah, so in terms of the overall excavation, it's 1,500, cubic yards of excavation. And I know that's not the answer that you were looking for. I don't know the percentage of grading.
But it's Culver's was 1720.
Yeah, and David's mentioning that the Culver House was 1,720 cubic yards. So we're, less grading on a very similar property.
Yeah, I was driving more at the, not the volume of export, but the portion of the lot that was being graded.
Yeah, one thing I could say, Bob, is that the area above the driveway, above that concrete crib wall, retaining wall, that's all natural grade. We intend for that to be a natural extension of natural grade. And the other thing I might add too is, since 2 design review board members didn't support this project because they felt that we were altering a natural landform. I mean, in our opinion, there's not a natural landform on the property. There's no rock outcroppings. There's nothing like that. It's a graded site. But if you push the house further back on the property to the top of the property, you're preserving a larger area of natural topography, natural contours than if you were building on the street, like the neighbors have been requesting us to build on the street.
Thank you. And we'll have additional time at the end of public testimony to ask additional questions. Are there any persons in support of the appeal that would like to speak?
Good evening, Mr. Mayor and council members. Morgan Gallagher with Cox, Castle and Nicholson on behalf of the applicant. I just want to briefly respond to the DRB majority's position that the site's natural beauty is a coastal resource. So I'm available for any other questions, but I just wanted to address that point briefly in a couple minutes. Staff and the DRB have acknowledged that there are no public views through the site. So my understanding of the DRB majority's opinion is that there is a public view of the site itself from the public right-of-way of the site, a sloped, previously graded site with no environmentally sensitive plants or habitat, and that is, in their opinion, a coastal resource. We disagree. First, the site is not a natural landform because it is not natural. There's a graphic that I can provide all of you that was included in the geotechnical report that was submitted today. About half of Lot B and about 70%, can I hand this to you? I apologize. Thank you. About 70% of Lot A has been previously graded, as you'll see in this graphic, from 1955. The site is not identified as a natural landform in the city's LCP Hillside Management Conservation Map or any other city document. The argument was made that the hillside appears to be natural, even though it is not natural. And that argument is not supported in the city's LCP, and the city has never taken that position as far as we can tell. There are 2 references in the LCP to natural resources as coastal resources. The first is visual resources, and the second is geologic and fire hazards, and that has to do with health and safety issues. The definition of a coastal resource includes, but is not limited to, public access opportunities, visitor and recreational facilities, water-oriented activities, marine resources, biological resources, environmentally sensitive areas, agricultural lands, and archaeological and paleontological resources. That is nowhere near a previously graded site that happens to be sloped in a neighborhood that was always planned for single-family residences and is surrounded by single-family residences. There's no precedent or legal basis for the site to be considered a coastal resource under either of those categories, and the city has never considered a vacant slope lot a visual coastal resource absent other facts. The City Council approved 1536 Morningside Drive in 2024, which is immediately adjacent to the project on that same hillside. There was no discussion of a coastal resource. The November 13th staff report specifically said that the vacant lot does not contain any coastal scenic resources. Even if there was a coastal resource, the impacts to the hillside are minimized. The DRB's preference was for an increase in grading to occur for the site, for the project to be forced down into the hill and for more grading to occur. And Chair Gibbs said that he happened to think that reducing the building further and terracing it into the slope, even if it might include more excavation. Can I have 30 more seconds, please? Thank you. Would minimize the alteration of the natural landform, and that is not the case. Increased grading does not minimize the disturbance of a natural landform, even if this were to be considered a natural landform. Just really briefly on the HAA issue, we believe that the HAA does apply, but even if it doesn't, SB 450 applies. Everybody agrees that SB 450 applies. And the city had 60 days under SB 450 to identify any inconsistencies with objective standards. So we believe that that in itself has the same result as the HA on that last issue that was discussed by city staff. Thank you so much for your time.
Thank you. Any other speakers in support of the appeal?
Yeah. Good afternoon, council. Thank you for hearing us today. I know this is a difficult project for everyone. I just want to address a few of the points made earlier. I'll speak in rebuttal with a little bit more detail. But the previous designs on page 30 of the handout I gave you to show the actual entire design that we threw away before we brought Horst on to really address these neighbors' concerns about bringing them into the process. Also, we stipulate to any conditions as cited by the fire department regarding it. And the DUDEC did provide an updated report on October 21st, which we provided, of 2025, which we provided to planning. The two hose pole designs in both applications are from that report. So it is not from 2024. It's been updated recently. And ultimately, it makes no material difference other than it complies with the design of the new house layout with the new right-of-way changes. Ultimately, we, as my attorney mentioned, we believe, and SB 450 specifically states, that all new development under an SB 9 lot split is protected. It isn't just multifamily. Multifamily is the only thing that the CDB will go prosecute actively, but they are protected even if it's a single-family home. And as for the ADU, we submitted that ADU at the time in September 25th, and it was ignored. And it's an optional addition. It's not what we're going forward normally, but we wanted to include it in the review because we didn't want to come back to this body. Our rejection was that they had the right to apply a variance to it because it's under 800 square feet. And because it's under 800 square feet, the criteria for the open space requirement doesn't apply. Now, we could make it, we could fix some of the things on the landscaping to get back that 800 square feet and be back within compliance. But we contend that there's no variance required under state law. Ultimately, because there is no coastal resource under the LCP, as my attorney stated, we don't believe subjective criteria can be applied to this at all. But even if it was, we contend that both the original designs we submitted last year and the updated ones all should be fully compliant to these discretionary DRB reviews for privacy, view equity, and neighbor compatibility. Thank you.
Thank you. Any other speakers in support of the appeal? None? Okay, then we'll move on to any speakers in opposition.
Hey guys, Joe Cover. I was a subject of the property that Horst was mentioning, and so just wanted to make sure to correct him. So the lot height that we've got is actually 12 feet higher at the max point than this project. This house is actually 3 feet higher than the top height of our project. So clearly we are not an average of like 15 or 17 feet or whatever he said, higher than the grade. Our average is like 6 feet higher than the grade, than the max grade. So just to make sure we correct that, that's definitely not the right metrics there. So for you guys, it's been about 3 years now since the first DRB meeting for Ed Riahi's property at 1526 Morningside. You guys heard that one. On the Morningside Bluebird Ridge, the knoll that we talk about. And since then, we've been through something like 10 DRB meetings, various planning commission meetings, countless hours with city staff, DRB members, all of you guys. And now we're at the 4th city council meeting to hear an appeal. We're only talking about 3 properties really. That turned into 5 because of SB 9. We all know that, we understand it. But only 4 actual projects. 2 of those projects were approved by DRB, and only My Family's project approval was upheld by council. The other one was denied. But even now, we are caught up in a lawsuit. And so neither of these two projects that we're talking about here were ever approved by DRB. The multiple meetings that we've had with one of them has already been denied by this council. No significant changes that are really helpful to any of us in the neighborhood. 3 years and still no resolution on any of these projects. The Morningside Bluebird Ridge is obviously a tinderbox. It's a tinderbox with a lot of very active stakeholders. It's this way because it's unique and amazing. Contained from traffic and noise. It's quaint, it's modest, it's eclectic, stunningly beautiful. The Ridge is a very special resource for all the people living on the upper Bluebird Canyon part, and for all of us that want to live there. It's special to the extent that we've all been in these chambers multiple times these past midnight to fight for the Ridge. So as to the question of, is this a coastal resource? Quite obviously it is. The conclusion of the staff report suggesting that the Ridge is a coastal resource is clearly correct. These two projects tonight are obviously the worst of the 4 projects considered on the Ridge over the past 3 years. There are many reasons they continue to be shot down by DRB. Those reasons were initially objective and subjective, and now in light of SB 9450 and all the codes that you guys have been talking about, obviously we focus on objectivity. You all know the codes much better than I do. I'm not going to bore you with trying to quote any of those, but really, when it comes to a comparison of our family's projects compared to these projects, the way that they're situated is so much different. We pull ours back into the hillside. It's going to make minimal impact to all the people, which is why we have broad community support. These projects are very, very close to the street. They're very imposing. They go very high and they go on top of the ridge line. So they look imposing from really all angles, from Diamond Crest over to Temple Hills, up the top of the world, all the way down to Lower Bluebird Canyon, which Lewis Whale said you can see from there. So at the end of the day, we're just asking that you see these projects for what they are: large, wide, tall, imposing structures that would completely change the look of the neighborhood and will focus attention away from the natural beauty of the Ridge for anyone looking all the way from those areas.
Can I ask a question?
Mm-hmm.
So can you explain what you said at the beginning about the height? I think you were talking about the height of your lot in relation to the height of his lot, and then can you explain that again?
Yeah. So that's one thing we noticed when, the first time around that they had come up with a structure. I think what Horst was mentioning was to help out Susan with privacy. They moved the project back, which also actually increased it. Even though DRB said to decrease the height of their structure, they actually increased it. And so when we took a look, really our structure goes, we have a max, I can't even remember the numbers now, but we basically have a max height of our lot that goes 12 feet higher than the max height of this lot of the grade. But our actual house actually goes 2 feet lower than the max height that they have proposed on this structure. So even though they're 12 feet lower in grade down the hill, their project goes actually 2 feet higher than ours. And so that's what I was kind of mentioning there, and how it can't be that we have an average that is greater than these ones when it comes to height to max grade.
Okay, that makes sense. And then, so the Ridge, if the Ridge is a coastal resource, explain how our decision on your property wouldn't have been a violation of coastal resources.
So decision on, well, I think the decision on our property based on coastal resources is that we do comply with all the DR criteria.
Okay.
And so there's no really reason that you guys would have had to go against it.
But are you describing the Ridge as starting like at a different point, or would the same Ridge be in the same area where your project?
I'm talking about the Knoll in general, just as a coastal resource, yeah. And so I think DR found that we had complied with all of the CDP findings and everything else that they needed to look at because of the way that we had situated our property to minimize all the impacts. And also because we have basically a large lot that we did not subdivide. And so a lot of that has open space that's in the front of the lot as well. And so there's a lot of the actual of our lot that is going to be kept contained with just landform.
Thank you.
Yep.
Other speakers in opposition?
Hi, good evening. My name is Eileen Slora. I live at 1545 Bluebird Canyon Drive. Statement of facts: despite being SB 9 and SB 450 projects, and I'm going to talk about lots A and B, they're explicitly subject to the California Coastal and LCP. City's land use element is one governing LCP document. CDP approval requires conformity with all provisions of the LCP. Objective violation 1, minimize the scale and bulk of new construction and/or renovation required development to be compatible with the surrounding residences. From the adjacent street level to the top of the structure, lot A is 52 feet and lot B is 55.
Excuse me, we need to just focus on the project before us.
Okay, so Lot A is 52 feet, which is equal to a 5-story building. The element, neighborhood compatibility, says new development should be compatible with the existing development in the neighborhood and respect neighborhood character, including historical patterns of development, structural height, mass, scale, or size. Comparing Lot A to 15 neighborhood-compatible homes, as defined by the applicant, a reasonable person can objectively see that none of the existing home comparables are 52 feet from grade to top, with very tall concrete retaining walls. Therefore, Lot A is incompatible with the character of the surrounding area. And, you know, I appreciate that Horst was hired on to develop this particular property. We were very excited about it. But you have a client, he's getting paid by the client. And even though Horst did listen to us, I don't believe that he took under consideration what we said, because he was being paid by the client, not by us. Therefore, we ended up with the properties that he designed. Although beautiful, I don't feel that they do belong in Bluebird Canyon where they're located. Thank you.
Thank you. Any other speakers?
Hi, good evening, Mayor Orgel and council members. My name is Pamela Adams. I live on Morningside Drive, the backside of Bluebird. I continue to oppose this project, Lot A, on the agenda today. I am asking you to uphold Design Review Board's denial and return this project to the applicant. The original Bluebird Canyon Knoll lot was carved up, taking advantage of California's SB 9 law into 2 smaller lots. I mean, smaller lots. When you look at the Cover lot, they didn't break theirs up. It's their full lot. So we're comparing apples to oranges, if that. So these 2 smaller lots that the applicant has is using for this project and the next project, this is a massive overdeveloped design presented to you. The design has not been reduced in scale or bulk for a new construction to be compatible with neighboring residences. The design sits on top of the ridge line of the knoll instead of being nestled into the natural topography of the land. I'm asking you to return the project back to the applicant to redesign, keeping in mind all the past DRB recommendations, the city council recommendation, and neighborhood suggestions. Thank you for your time and consideration.
Thank you. Next speaker.
Good evening. I'm Peter Groman. I live directly below the project, 1573 Bluebird Canyon. Throughout the whole process, one thing the applicant has not done offer any kind of change as far as the location, which is currently on the ridge, and as far as size is concerned. The project is huge. It will create a beacon in an area that is right now at night totally dark. The construction of the home with a street that is limited to 3 tons. It will, with the amount of export that has to take place, it will put an extreme amount of stress on the road. The hillside presents a very challenging location to build a home. While financial considerations might point to, yeah, let's make it a big home or big homes. the next lot included. But the bottom line is that should not be a reason to approve two huge homes there. So I ask you to support the decision by the DRB and go forward or do not go forward.
I'm William Horner. I live at 1565 Bluebird Canyon, directly across from this project and the adjacent project at 1560. I'd just like to note that Laguna Beach has obviously long treated hillsides, ridges, and canyons as coastal resources. This knoll is visible from throughout Bluebird Canyon, directly from the neighborhood, from Molten Ridge trails, which are some of the most heavily used by the public, and Arch Beach Heights as well. These are the exact types of public view sheds the Coastal Act is intended to protect. The evidence supports the DRB's finding against these projects that they don't meet the CDP or LCP standards. Structures 52 and 55 feet above street grade, 400 feet of retaining walls, over 90% of lot area graded. This is clearly alteration of a natural landform, not integration. There is a reasonable path forward here to development. Integrate into the hillside and preserve the desired square footage, or keep the hilltop siding and reduce mass and scale. Either approach could work. What doesn't work is both. Maximizing mass while also siding atop the knoll. That combination is what drives the landform alteration and the extensive retaining walls that the neighbors object to. The project was redesigned when it was handed off to Horst, but the redesign didn't address these core issues. The DRB provided clear guidance. That guidance wasn't followed. I'd ask council to review the complete documentation in Harp Hall and Susan Whitton's submission. It provides perspectives and renderings and details not shown tonight that better represent the impacts of these retaining walls and the siding of the projects. I believe any reasonable person reviewing that material would have difficulty concluding this project minimizes alteration of the natural landform. The path to approval exists. I ask you to uphold the DRB's decision and allow that process to work. Thank you.
Thank you.
Susan Whiten, 1540 Bluebird. Good evening. First, I'd like to say there are 5 people who on Morningside that are out of town that can't be here tonight, and 2 people that are sick. So we're missing some of our group. Question before you is whether this project, as currently designed, meets the objective standards required by the Coastal Act, the local coastal program, and public and safety regulations. They do not. It does not. The DRB properly denied the projects because required CDP findings could not be made. Specifically, finding 1, criteria 5 and 6, requires minimizing alteration of the landform and compatibility with the surrounding neighborhood. Those standards remain fully applicable to SB 9 and 450 development. Applying the objective standards, the project fails to comply. The applicant's own FAR comps in the neighborhood, in addition to the submittal drawings, shows excessive building mass and height relative to the landform and neighborhood. It shows a 50-foot tall structure in a neighborhood averaging 15-foot structures. It shows houses elevated approximately 14 feet above the natural landform, a garage roughly 16 feet above the street level in a neighborhood of street level garages, and tall, nearly continuous retaining walls along a street in a neighborhood that has no street level retaining walls. These are objective, measurable metrics that conflict with the LCP. Additionally, independent grounds for denial exist due to roadway constraints. The plan shows an 18 to 20 foot wide road. However, at some locations, the road is less than 18 feet. Critically, no roadway improvement plans have been prepared. Without approved road design, the final road edge is unknown, and the building plans may not be feasible as drawn. Proceeding with development before resolving roadway design places the development sequence out of order and risks requiring substantial redesign later. The sequencing problem alone supports denial of the projects as designed. For all of these reasons, the project as currently designed cannot support the required findings, and I respectfully request that you deny the appeal. Thank you. Thank you.
Thank you. Any other speakers?
I think I may be the last. Mayor Orgill, members of the City Council, Harpal Settle, resident of 1585 Bluebird Canyon Drive. As you deliberate on the applicant's appeal of the November GRB decision, I ask you to consider a few brief points. First, it's no coincidence that homes in Bluebird Canyon require a CDP, and that issuance of the permit making all criteria findings is critical. The bar is high for a reason. Bluebird Canyon is designated as an area of deserving careful consideration, and the city has been deputized by the Coastal Commission to issue CDPs by way of the certified local coastal program, which clearly you know, in order to protect hillside visual resources. This is a specified carve-out from more blanket state housing laws, again, for a reason. Were Bluebird more uniform, flat, and tract-oriented like Arch Beach Heights, it would have been excluded from the CDP requirement. Lot A is objectively and measurably incompatible with the existing neighborhood. Specifically, when you look at the height from the adjacent street grade, Lot A is about 52 feet from the driveway grade to the top of the structure. It's equivalent to a 5-story building, as has been said previously, 5-story office building. And that's sitting among other more modest family homes about 40 to 60% lower. The applicant himself through this process has multiple times submitted floor area ratios to DRB. So why does this matter? Well, this sets the fact pattern that the compatibility was a knowable and known measure that the applicant was attempting to conform to, something that was important. So we support the development of this parcel, but in a manner that integrates with, not dominates the neighborhood as the tallest and largest structures. Thank you.
Thank you. Any other speakers? Okay, then we'll move on to the appellant's rebuttal. 2 minutes.
Can you please put up?
Put up the presentation, please.
I'll start when that's up. And you can move to page 47, which shows both homes on there. A couple of quick notes. The home, its highest elevation above the street is actually 48 feet and 46 from the driveway entry at 467 to the height of the rear lot. Obviously we could have trimmed the east edge of that roof from 515 to 513.4, which is the cover's height exactly. But that was not what we were asked to do. We were asked to remove 8 feet. Now, to be clear, on both of these projects, but focusing on Lot A, the first floor is obstructed by the neighbors' homes and other things on the view line for the ocean and Catalina. The only Catalina view we have is from that second floor. And ultimately, that second floor is only on half of the property. So we've done a very good job of minimizing the height of that on the hillside. In specifically, the average height of both projects is lower than 12 feet above existing grade. Cover's highest point on their west side at its maximum is about 10.5 feet above. So generally, we are consistent at that measure. But in your documents, I've given you a number of comparisons, primarily to Lot B, but that are equivalent to the setback conditions of Lot A. And ultimately, they projected the same dimensions from the curb to the frontage of the home as the Cover one does. So its articulation, its position on the hill, which is consistent with the neighbors, and its size, which is reasonable for a large flat lot on that spot, or a slightly graded uphill lot. And the answer to a question that somebody else had made earlier, how much excavation is there? The entire left side is on grade, and the right side walks out under grade, and so 50% of that lower floor is graded from 2 dimensions. So about 1/3 of the total volume of the lower floor is graded.
Thank you. Are there any staff responses to the rebuttal? Okay. Does any of council have any questions of the appellant, applicant, public, and/or staff?
I just had a chance to quickly review the geological letter that came in today, but could staff summarize that for us? were there any significant takeaways from that?
Absolutely, Councilmember Whalen. The memo prepared by the applicant's geotechnical expert generally agrees with city staff's review of the grading history of the knoll historically. There was some amount of grading that occurred near the ridge of that knoll for purposes of constructing an access road to that extant water tank. They also documented, I believe it was a 1.5 foot depth of undocumented fill within portions of the knoll.
Okay. And were those fills at the ridge, on the ridge, or down lower? Did they specify?
I don't believe the memo specified,
Okay.
but the applicant may be able to clarify that point.
Any other questions before I close public testimony?
I can address that point. It's on the edge, as they graded that top where the home is primarily sited. They graded some of the dirt on the south and north sides. So it's on the edge of those ridge lines that currently exist where there is the most fill. That's per the geological report. This letter doesn't detail, but if you look at the geological report, it shows that.
Does that answer your question, Bob? Any other questions? Okay, then we will close public testimony and bring it back to council for deliberations. Would like to start? I choose Alex.
Well, there were a couple of issues that were raised
Bob's
that
gonna take
I'd
them.
like maybe legal counsel just to speak to, which is the contention by counsel for the applicant that, you know, under SB 9, you know, we failed to process within 60 days. My understanding is that with respect to the CDP, that's not applicable, but can you speak to that for the record?
That's correct. Under SB 450, there is the carve out for the Coastal Act. There is no requirement that the actual CDP be considered and acted upon within 60 days, just that the building permit for the ministerial housing project be considered within 60 days. So even if, for example, which is not the case here, the building permit were deemed approved, there would still not be a coastal development permit that has been deemed approved by operation of law. And this is also supported by the fact that the state ADU law now has a provision that requires action on a CDP within 60 days, and that's notably absent from the SB 450 law.
Thank you, Jane. I'd like to make a correction. I think I might have misspoken and closed public hearing. It was, I was closing public testimony. So I just want to be clear on that.
That's what you said.
Okay, great. Just wasn't sure. I was questioning myself. Okay. Any other council members?
Start.
Yeah.
Okay, so I think so I would just start by just to kind of clarify some of the high level issues that Bob just brought up. So for purposes of this, there were issues in the appeal about like the approval of the ADU. That's not part of this, correct? And it's not Housing Accountability Act. So that's my position there. I don't agree with the applicant with respect to that. And you know, before I provide my comments, I just want to say this is probably, I think I said this last time when we dealt with the ADU issue in North Laguna, one of the appeals where I've put, you know, the most amount of time into and just trying to understand all the issues at play. Because I think as council members, we have really an obligation to, you know, to the extent allowable by law, to protect the character of neighborhoods, to follow the precedent of our design review board process, which property owners have, you know, sort of bought into when they come to Laguna Beach. But with that being said, I think we have to follow state laws and be limited to the extent that the law provides, in a way where we're not subjecting ourselves to lawsuits and significant penalties. I think we also have to think about our CDP authority in a careful way, where if we were to just use that sort of as a basis to apply, you know, design review criteria, for example, as an extreme case, I think that very quickly, and we saw that Jane referenced how the state law changed for ADUs with the 60 days. I think that we're sort of in a situation where we have to think about these projects in a really strategic way and look at all of the relevant laws and tools. So, as I'll just start by saying that if this project came before me, and I wasn't on the council 5 years ago, but I don't think I would have approved this project based on the design review criteria. I think that I would have, and I still do wish that the applicant had collaborated with the neighbors to find a project that could satisfy different needs and sort of follow the traditional process. But it's not right now. We're in a quasi judicial rule. It's our role to protect the interests of the city and to follow the law. We're not here to make the law. That's what the legislators in Sacramento are doing. And so as I look at the issues before us, as making the subjective findings with respect to our CDP on substantial evidence, I have a very hard time justifying the denial of the CDP here. And I think I'm going to segment this into sort of three issues, because number one is public safety. That always has to come first. Even the Housing Accountability Act has a carve out for public safety. We never want to approve a project that does not comply with, fire access requirements or anything that makes people less safe. When it comes to public safety related decisions, what we do is we have our fire marshal, we have staff who interpret the fire code in a way. And so based on the memo that was submitted to the record and what our fire marshal, the testimony provided earlier, it seems like the road access issues are resolved. And then to the point that Bob was bringing up with the study about geological hazards, there's no evidence to suggest that there's any geological hazards related to this. So then it sort of becomes a de novo question of how do we make the CDP findings. And Design Review Board, and I watched that meeting 3 times, and really tried to dig into what they were saying, and we have to make look at the evidence and make our own determination. But I think sort of there with so with respect to there was testimony today about how the city of Laguna Beach, we've long treated undeveloped hills as coastal resources. The problem that we have with that is that's just not really reflected by our past actions. I mean, on the Cover project last year in 2025, we did not treat this as a coastal resource. And I pulled up the resolution, and this was in the environmental context section for purposes of design review, but I think it would apply. And where the resolution and the findings were that the property does not contain significant natural features, such as, and talks about trees, outcroppings, watercourses, or prominent ridgelines identified in the open space and conservation element. This is not mapped as high-value habitat, nor does it contain watercourses. The city's design review guidelines recommend that the development minimize alterations to the site's significant natural features, maintain natural slopes to the extent feasible, and avoid building on the crests of knolls, ridgelines, and prominent locations. And the grading on that site was 1,720 cubic yards, and I think that's pretty comparable to what we have before us here. I guess that's a bigger lot. So I have a really hard time making a substantial evidence finding that there's a coastal resource involved with this natural landform when literally less than a year ago, we looked at the same area and we did not come down, we did not identify that as a coastal resource. I think a court would look at that and it would be a very clear basis by which they would say that there is not substantial evidence to base a decision to do that. And then so then it goes to the Chapter 6 policies. And I think the issue here, and this was sort of the crux of my questions at the beginning before testimony, was about, what obviously our LCP includes design review criteria. And I think everyone here agrees, everyone in this room agrees that we're not, if we were to just apply the whole LCP, we would apply the design review criteria. I think what the statute says is it creates a savings clause for the Coastal Act. So then you have to go to the Chapter 3 policies of the Coastal Act. And so our specific CDP finding number 6 states that requires a determination that the proposed development will be visually compatible with the character of surrounding areas and where feasible will restore and enhance visual quality in visually degraded areas. And so this is basically implementing Article 6 of the California Coastal Act. But when you read Article 6 of the California Coastal Act, what that says, I'm trying to pull it up, is it talks about, it says where appropriate, protect special communities and neighborhoods that because of their unique characteristics are popular visitor destination spots for recreational uses. So when we really look at this from a Chapter 3 Coastal Act perspective, which is what I believe the law requires us to do, I have a hard time making a traditional neighborhood compatibility argument that we typically would do under our design review criteria when Chapter 3 policies don't talk about protecting special neighborhoods just because they're special. I agree it's a special neighborhood, but Chapter 3 policies are about whether it's a special neighborhood as a popular visitor destination point, which is sort of what the Coastal Act is all about. And so I just can't, based on substantial evidence, make those findings. It's a hard decision because, I really respect all the neighbors involved and I've tried my best to understand to the extent allowable by law, can we make the CDP findings? And I think at the end of the day, sometimes you have to make unpopular decisions and in the best interest of the city, in the best interest of our long-term Coastal Act authority in the context of these ever-changing laws. And so I think that, based off all everything I've looked at as I've studied this closely, as I know our staff have done a great job diving into this, I cannot make the findings for denial. So I would, reluctantly in a way, but based on just my empathy for the neighbors involved, but based on the law and what our obligations are, I would have to make the findings to approve the coastal development permit. So I'm interested to hear what my colleagues think and on this very complicated issue. So anyway, thank you.
Thank you. Other council comments? Sue, do you have anything?
I think it's a very comprehensive analysis that Alex has gone through. I sort of divided this into procedural challenge and then sort of the substantive issues. And the procedural, I think our council and staff have addressed, very well. I find that all the procedural claims that the applicant has raised are without merit, including that the HAA applies, that the project is deemed approved, that the DRB's imposition of subjective standards violates state law. I think clearly we'd get to apply subjective standards in the CDP context here, and that the 30-day inconsistency letter, DRB violated that. I think it's clear from the record and from what our council has provided that none of those procedural challenges have any merit. I agree with Alex that the natural landform criterion 5, it's really hard to find enough in the record to determine that that's a natural landform, especially in light of the vote on the Carver project, which I'll just note for the record, I voted against because I think there are some aspects of this, but that notwithstanding, that's what the city's on record is providing. I would like to have a little more conversation about criteria 6 because, as to whether or not that still applies, because I think this project is visually incompatible with the neighborhood, no question about it. The way it's sited on the property, the way it sits atop the ridge. The other project that was approved does not do that. It's down at street level and proceeds up from there. But you have to tie that back to, to a coastal policy, right? That's applicable in our LCP. And I don't know if staff or anyone else on the council has thoughts on that. I mean, once you determine you don't have a natural landform for the criteria 5, I don't know what's left to apply, what would be left to apply for criteria 6. But I think the neighbors make a compelling case that it's not visually compatible. It just sits atop the ridge. It's the highest thing in the neighborhood. So from from the literal words of that finding, you can say it's not visually compatible with the surrounding neighborhood, but with the character of the surrounding areas, I think is the exact language. But you still have to find that impacts a coastal resource. And so that'd be my question, I guess, of staff. Is there any coastal resource that's impacted by the visual incompatibility, in my view, of this project with the surrounding area?
Madam Attorney, do you have any comments on that?
Mr. Mayor, Councilmember Whalen. Well, I think that this is the tension of the Coastal Act that we're experiencing up here, is that our LCP policy says, that we apply the our CDP policy. Sorry, I'm not totally on my A game tonight with this mask on, but the CDP finding 1 criteria 6 says visually compatible with the neighborhood, in essence. And so to Councilmember Runagi's point, we look back to the Coastal Act as to how to implement that. I think that DRB in their analysis tried to do that a little bit by the identity of land use policy 10.2. And staff has a couple slides that may be helpful to look at some images of the area to help sort of further to sort of have a bird's eye view of the project too, to kind of take a step back and see the neighborhood from a visual compatibility perspective. So Mr. Vieira, if you don't mind firing that up.
Mayor and Council, this is an oblique view of the project location and its general context within the Bluebird Canyon neighborhood. Closer to the foreground, you have the homes that slope down above Jefferson. The knoll is towards the middle of that image. You do have a lot of variation in topography, how homes are sited on the lots, the extent that the development occupies those landforms. And here is one more view looking up towards the knoll as you're traveling from the coast along Bluebird Canyon towards the back of the canyon.
Thank you. Is there something you'd like to say, Jane?
And then just to kind of supplement in response, I think, to the 2 comments here, by members of the City Council and in anticipation of the remainder of the deliberations. As we know, SB 450 has the carve out for the California Coastal Act. And so there's really 2 ways of looking at it. One, what city staff thinks is somewhat of an extreme way to look at it is that the city's, LCP, as certified by the California Coastal Commission, is the Coastal Act, and therefore, apply everything within the certified LCP, including design review, which protects things such as privacy and view equity, such as private views, which is not contained within the Coastal Act itself, or to take a view that California Coastal Act savings clause that's within SB 450 is focused on the Coastal Act itself in its most purest and truest form. And I think in response to the question about visual compatibility, that is within the Coastal Act. And so that is something that the City Council can consider. City staff would advise, however, that it be based on, substantial evidence in the record that's supported based on prior actions of the City Council and the DRB in that specific neighborhood, to make sure that the findings are well supported in the record.
Did you have another question, Bob? Follow up? Any other council comments, Sue?
So just on that neighborhood compatibility question, what Jane was just mentioning. So when you showed that aerial picture, can you put that up again, you guys? So the Cover House was approved, right? And it was terraced in. The rest of these homes here on this bridge, they're all terraced. And they look big from this angle, they're all terraced down. So if you're walking down the street, they're not tall. They're kind of at the same, they're kind of they look like a one-story house from the street. And then if you walk down like Jefferson or something, you can see the fact that they're all terraced down. So I get the complexity of this, but I was just wondering, these houses are terraced and so is the Cover House. I'm not sure where we go on this, but I don't know about this example. That doesn't really necessarily illustrate anything, but houses are terraced.
Do you have any comments, Hallie?
Yeah, I think for me, the key word here is minimize. We keep talking about these coastal resources and we talk about minimizing impacts on these coastal resources. And I just don't see that the way the house is situated minimizes impacts on coastal resources. I don't see that I can make that finding.
Thank you. Well, as we've worked through this process and we've all worked hard and, evaluating this, and I think that it's been a tough process for us all. And myself personally, we've, had the, advantage of meeting with the applicant and then those in opposition as well as council. And I've spent, a lot of time with council discussing this and, becoming familiar with all the various pieces of legislation that affects it. And by the way, I have asked Megan to work with me after this just to help the community better understand some of these issues because I know it's hard to take in. And I know there's been some effort in the past to address some of them, but I think that we need to make continued efforts to help the community understand what we're up against. But with that said, if there's no other comments from council, I'm going to go ahead and close the public hearing and then we'll bring it back to council to make a motion. So that public hearing is closed and then we can deliberate on a motion.
If it may assist the council, I think there is a backup slide with questions presented for the council's consideration on substantial evidence.
Would that mean reopening the public hearing?
The public hearing, not public testimony, just so that the evidence can come in.
Okay, then public hearing. We'll reopen the public hearing.
So presented here are just a summary overview of questions relating to the CDP. It would be what substantial evidence supports DRB's finding for criteria number 5, that the development will minimize the alterations of natural landforms. And then what substantial evidence, if any, supports DRB's finding for criteria number 6, that the proposed development will be visually compatible with the character of surrounding areas. And those I think are the two that the City Council is trying to focus in on. And so I think that those 2 bullet points will assist the City Council.
Well, in terms of visual compatibility, the evidence that we received, from some of the neighbors showing relative height from street level, I think is the only evidence that I've seen that really kind of goes to the compatibility question. And, this project, height from street, is the highest of those. Now, what I am not sure about is the cover project. We have that. We know what that is from height from street.
Councilmember Whalen, I don't believe we have that number available, but staff did do a review of the height of the cover project above the highest point of the knoll within the lot boundaries and compared that to the proposed project by the applicant. And I'll have Associate Planner Daniel Latham provide that information to you.
So looking at the plans from the Cover property, I have the 15 or 515 elevation of the highest point of the ridge line. And then the highest point of that property being 513 at the corner. So that would mean that this project is 2 feet above the highest point of that particular property.
2 feet.
2 feet, approximately.
Any other questions?
Can you just say what you said again? What's 2 feet? Higher than the
2 feet from the highest point of the structure is the difference between the highest point on the lot for the Cofer property. Meaning the structure is 2 feet above that highest point.
So the cover, like the top of that house, is 2 feet above the highest point on Mr. Durnay's house. That's what you're saying?
Not necessarily. No, the highest point on the Cover property, which is the
lot
highest
itself.
Yeah,
is 2 feet higher.
the structure itself, the proposed or the approved structure, is 2 feet above that highest point. So if we have 515 and 513, 515 being the structure, 513 being the highest point of that lot.
And Mayor, if I may expand on Daniel's response, the height above the driveway elevation for the cover project is approximately 47 feet.
And this one is 52.
What I'd like, maybe because city staff did do a comparison for visual compatibility purposes, I will put up a slide on the screen that using as a metric max height above knoll, we did a comparison of the two projects proposed by David Durnay, the applicant, and the cover project. And we'll bring that up in a moment here.
Are the heights that you're referring to taken from the center of the property on the street?
The highest point above the knoll is what's being reflected in the table on the screen here. So based on staff's review of the plans for the 3 projects, and for this discussion, I'll focus in on, for purposes of responding to Councilmember Whalen's question, 1550 Bluebird Canyon, 1560, as well as 1536 Morningside Drive, which is the Cover project. The Cover project, to the height of the highest roof ridge measured to the highest point of the knoll on that same lot, the roof ridge is 2 feet above the knoll. For 1550 Bluebird Canyon Drive, the appeal currently being heard, it is plus 13 feet. 1560 is plus 12. I will say that based on the irregularity of this landform, the knoll does fluctuate in height along the ridge.
I think we also can't discount, a structure being terraced back into the hillside, even with a high maximum height. If you've got that terraced structure, it's not going to look as visually imposing as a house that has not been terraced that way.
And I agree with that. The only thing, there's a difference though, because even if it's folded back into the hill and it obstructs the whole knoll or ridge, then the landform is obstructed either way, right? So I get your point as far as dealing with mass. So any other questions before we close the public hearing, or Bob, anything?
No, well, no, nothing further on that point. I think we ultimately does come back to, the question of substantial evidence in the record. So, again, I come back to, it seems like the factor that we have is, the two factors we have is height above the knoll and height from the street level to the highest point of the project. And I think on both of those counts, the 1550 project is the most impactful. Now, there's, so that would go to the criteria 6. Anyway, it's a tough decision. I think Alex made some good points early on, which is, we can sit here and make a judgment and, is it substantial evidence or is it not substantial evidence given the whole mix of things that we've seen? And it's a hard decision to make, right? I mean, I think there's, it's just a tough one. I think, so anyway, you were going to call for a motion, I guess.
I'll close the public hearing and, yeah. Sue, did you have any final comments?
I was just wondering, could we, so it's taller, right? So, it seems like there's some, we're struggling with a little bit of the visual compatibility here, but could we lower the plate heights? Would that help? But, that's the only thing I could. Because to me, and I've said this to David, I think the terracing is what's really bothering people.
Is there any interest from other council members for me to reopen the public hearing and ask the architect what our options are regarding that?
Good idea.
Okay, I'll reopen the public hearing and ask for Horst Knoppenberger. So what we'd like to ask you is what the options are regarding lowering the plate heights.
Yes, we've discussed that briefly. We can absolutely lower the plate heights. Just a quick clarification, because I believe the question that was being asked is what is the height of the Culver House and our project from street to the highest point of the structure? And what staff responded with is the height of the highest point of the structure relative to the highest point of existing grade on both properties. But what I can tell you, in terms of another metric, is that we are very consistent with the Culver House from the street level to the top of structure, which I think is a much more clear, much more intentional, much more gaugeable metric than how high the structure is above existing grade, because existing grade is irregular.
So I appreciate that, and we're going to go back to
and the answer is yes.
Sue's request, but briefly,
Okay.
I would like some clarification. So, and I asked the question earlier. So when you're talking about street level, because the street is obviously on a grade, what point of the street? Uphill side, downhill side, or in the center?
Bob suggested at the middle of the property.
Okay,
And that's kind of,
the middle, that's all I needed.
those are the studies that we did, and we're within a foot of the Culver House.
Great. Okay. So now the question Sue was asking is, could we lower the house, the plate height?
Yes, we could.
specifically?
Yeah, and we've
On
discussed
both
that.
stories?
Yes, we could lower the plate height by at least 2 feet.
So that would give you 4 feet? Is there any room in the garage?
We made this offer to the board and we said we could bring the height of the building, especially on the east side down.
Hold on a
8 feet.
second.
That was already made.
Correct. And so, Mr. Mayor, I would just advise you to limit the comments to the questions asked and not.
Okay, so Horace, let's just, thank you very much, Pat, for straightening me out on that. So again, specifically, you can lower the plate height 2 feet per story? Top story 2 feet?
We were looking at right now we have 9-foot ceiling heights. Actually 10 foot on the lower level and 9-foot mark on the upper level.
Okay.
We could lower, I would say, a foot at the lower level and a foot at the upper level. That would be 2 feet. We could also, if the council required more to get an approval, this has been such a long road for us. I think I can convince David to slightly lower the house as well on the site, if you're looking for 3 feet, for example.
Okay, well, we need to stick to, help me follow the rules here. Yeah, would you like to ask the applicant, Sue, what his, what the maximum he'd be willing to lower it?
I'm just asking the question first to see if it was feasible or they were.
So it's feasible, we know that.
Yeah, okay, yeah. I mean, so there's that question, and my second question is maybe for staff or for Horace. Could we also do some more terracing?
Yes, of course, absolutely. I mean,
Yeah.
we do have that large open space at the front of the house with, with the trees, that large landscape area. That is existing grade, but we could certainly find ways to terrace the front, lower the building slightly. Yes.
So now the question is, how do we get through this? Do we try to put conditions of approval on this, or do we have it brought back? Do we try to redesign it from the dais?
You have one more hearing. You're at your 4th hearing, I believe. So you could bring it back. I don't know. My architectural skills are going to fail me here. So I don't know how you can, if you can do it tonight. I'm going to look to staff to kind of help us answer that question. If you can do it tonight, you certainly could do it that way.
Okay,
Yeah.
let's ask Anthony. Anthony, how do you feel about the options that Horace provided?
The additional terracing, I think, would be difficult for staff to interpret and craft a condition of approval for this evening without receiving additional information outside of this hearing, receipt of plan information that staff can review, confirm complies with applicable development standards, and then return with the appropriate resolution of approval. A condition that limits the overall height of the structure would be easier for city staff to present for your possible adoption this evening.
But if we decided on both, and wouldn't it make sense that we just do both?
Correct.
We
Mr.
brought both of them, so I'm not sure. Can you instruct me on how we might move forward with that? Would we leave the meeting open or close it?
We would leave the public hearing open and continue it. I'm wondering if it's possible to take a few-minute recess so we can talk to staff about the condition, like what's being discussed and like what conditions can be imposed tonight, and just have, so I think we're trying to figure it out in
Sure.
real time, and
That's
it's not
fine.
super
I understand.
productive.
So how long would you like?
5 minutes.
That's fine. 5 minutes. We'll
Thank you.
keep the public hearing open and we'll take a 5-minute recess.
I mean, that's right. We can.
Indeed. So, Horace, can you come up to the? So we can either continue the hearing or we can condition it this evening, which would you?
Correct. And so, Horace, but before you do it, I think what we want to do is maybe lay out staff's
Okay.
analysis and reasoning. They'll
And then
fully
give them that
hear the
choice.
condition. And then, of course, Horace can kind of
Okay,
go ahead
thank you.
and talk about it. So, Mr. Mayor, so what staff is hearing based off of the previous direction is that the city council via its Coastal Act authority cannot make that visual compatibility finding due to the current height and lack of terracing in as proposed. That substantial evidence in the record could support making that finding, subject to conditions as discussed by the city council, at which point I'll turn it over to either Mr. Planning Manager or my esteemed colleague to kind of explain that condition because they're much smarter than me.
Thank you.
Thank you, Mayor and Council. On the screen is the condition of approval as drafted by city staff. Applicant shall reduce plate heights and/or perform additional grading within the building footprint to lower the structure into the hillside so that the roof ridge line overall is reduced by a total of 4 feet. Staff did want to point out that the plate heights as proposed range from 9 to 10 feet. The applicant could consider reducing some of those plate heights to 8 feet, and that can be in conjunction with sinking the building into the site, so doing additional grading inside the structural building footprint to achieve that overall 4-foot height reduction.
And just to add, so a condition of changing the designs and plans to create this terracing is probably not an option tonight. And so that'll be left to the applicant to decide whether or not this condition is acceptable, or if the idea of it not being and they want to rework it and make it more terraced, that is, of course, your guys' decision. Thank you, Mr. Mayor.
Thank you. So what do you think?
Yeah, so we took a very, careful examination of the plans. We have 10-foot ceiling heights on the main level. We currently have 8-foot ceiling heights, with the exception of a slight roof over the master, but we have 8-foot ceilings at the upper level. We wanted to see if the council would be willing to have us reduce the project by 3 feet. And we know we can do 3 feet very easily. The other constraint, and I'm sorry for the long answer to a simple question, the other constraint is that our main living level at 492, the Whiten house has a roof at 495.2, so that top of the roof is 3.5 feet. So from our main living level, we can stand up, we can see over that roof and have some ocean view, but if we're sitting, we're not going to have an ocean. So those are our constraints. I know that we can get 3 feet. I'm hopeful that we can, earn the majority of the council members' votes with 3 feet.
Comments from council?
And pursuing this would take the terracing options off the table. Am I understanding that correctly?
No.
No, so basically the terracing option, and Mr. Planning Manager, interrupt me if I'm wrong, that is such a substantive change that staff would need to see, different plans and kind of where it is, whereas this is, a condition like this can be implemented tonight.
Yeah, from our perspective, and this idea of terracing has come up. It's very vague what that actually is. It's very ambiguous. We can having been a design review board member myself, we can very easily say, okay, the roof height needs to be 3 feet lower. That's very objectionable. It's very monitorable, if that's a word. But creating terracing, we can do it, but it's sort of ambiguous what that really is and looks like. And
So I guess just in terms of process, we're looking at 2 options. We're looking at an option which is to approve this tonight with this condition, which is a decrease of what the applicant is requesting to be changed to 3 feet, or asking the applicant to come back with a more terraced interpretation of the project. Am I understanding that those are our options on the table?
Correct. And Mayor Pro Tem, city staff would ask that the council try to provide additional direction as to what the council expects in terms of additional terracing of the site and/or the proposed structure.
I'm interested in hearing my colleagues' opinions.
what does additional terracing mean? I was more focused on the height above the ridge, which this condition would address.
I would personally, on this particular project, be okay with the reduction in height, just because of the fact that it is pushed back. There is the front yard portion already so it is pushed back from the roadway. So I would be okay with just the lowering personally.
And is there consensus on the 4 feet versus 3 feet?
Would you like Anthony to restate where the 3 feet would get us with the ridge line or the knoll line? Can you restate that, please, Anthony?
Absolutely. Give me just one moment. The project as currently designed per the plans presented to the board on November 13th achieve a maximum height above the knoll of 13 feet above the highest point within the subject property lines. And as such, we're looking at potentially bringing that to +9 with a 4-foot height reduction.
Okay, so now first of all, are we okay with the process or the idea of just lowering the house versus terracing? And then we would have to discuss the proposed 4 feet from staff versus the applicant's request to consider 3 feet. Do we have any opinions on that? The 3
As I
feet
said,
versus the 4 feet?
I'm more focused on the height above the ridge line. I don't know what terracing.
Okay, so how
conceptually
about the
people
3
have,
feet
so
versus 4 feet?
I'd rather see the 4.
I mean, 4 feet would be good if so I guess maybe a question for legal counsels, is there I know like on the Pearl Street case, we got in trouble because we reduced the square footage of the house, right? And that was reducing density. Is reducing height, does that treated? I know this is not Housing Accountability Act, but I'm sure similar provisions would be in the statute. So I don't know, question.
I can answer, Mr. Councilmember Ranagi. The provision on the denial or conditioning for a reduction in density is actually specifically from the Housing Accountability Act, so that provision doesn't apply here. But in any event, we're not reducing. The reduction in density is interpreted by HCD as a reduction in square footage, not cubic feet.
Mm-hmm.
And so we're not reducing square footage with these changes.
So Horst, what do you think about 4 feet?
I think it's doable. And also, I mean, even beyond that, I think, given the discourse we had this evening, I think it's reasonable and fair for everybody.
Okay, then are there any questions of Horst before I close the public hearing?
So it sounds like to close the public hearing.
Excuse me?
Close the public hearing.
Well, it looks like has something else to say.
Is getting a lot of pushback from the person who invested a lot of money in this project and time. He would like me to get ask for a straw vote at 3 feet and figure out where we are.
So I've already asked council for their
So
input.
4 is going to be the number.
4 is the number. Hold on a second.
Just one question.
Wait, I can't.
Is
I
that
can't take any. Just hold on. Go ahead.
Mr. Mayor, it's at your discretion if you'd like to hear from the
Okay.
applicant or his
Mr.
representative.
Daenerys, you can speak. I'm just trying to follow protocol here, so just be patient.
apologies? My concern about that number is I've lived and breathed this thing for a long time, and that number pushes us down in ways that are very difficult to accommodate. Now, I know Horst can almost do anything, and he's an incredible designer. But I would ask that that be the only condition if it was 4 feet.
So you would agree to 4 feet in the record?
If it was the only condition for approval.
Well, just for clarification,
Like the only additional condition?
you're saying, okay, we did have earlier tonight, the fire marshal had a few additional.
Yeah, I stipulated that
So
we
you're
agreed to
okay with-
everything there and recording on title. That's no problem. I would very much respect that report. It was very comprehensive. So
So-
I'm just saying, I don't want to be nickel and dimed on this, okay? That is a painful number for me to accommodate, and it's expensive to redesign this stuff, especially with those changes. So I just can't accept more conditions beyond that.
All right, so let me ask council where they are with the height and if there will be any other suggested changes. Are there any other suggested changes other than the height from any other council members?
I don't have any.
None?
I mean,
Okay.
it seems like if you take the argument, which I don't know that I'm sold on, but let's say we assume, I think there's a good argument that could be made that there is, the Coast Chapter 3 does protect visual coastal resources. And then I think the metric that Bob articulated, I think is a good one. And it sounds like this would address that. And so so I would be,
So we
especially
would
with
be
the
limited to
applicant,
the reduction in height.
like you're saying, in terms of additional things that we want to add to it.
Yes.
Yeah, I think that based on the framework that was discussed earlier about comparing this to the covert property and the height above the knoll, it seems like this achieves that metric.
Great.
If it may, assist the council, there is a staff prepared revised resolution that makes some minor modifications to the CEQA section, and also that addresses the fire memo and what was added by the fire marshal this evening. And so I think perhaps if Mr. Vieira can pull up that revised resolution that is the conditionally approving resolution, and then it sounds like the applicant is agreeing to the condition of approval to lower it the 4 feet. So to also add in as a red line in that resolution for the city council's consideration.
So this resolution on the screen here is the resolution that Assistant City Attorney Jane Abzug was alluding to. This is a resolution by the City Council overturning the Design Review Board's decision to deny the coastal development permit, and in so doing, conditionally approving the design review and coastal development permit applications, and also finding the project categorically exempt from CEQA pursuant to the Class 3 categorical exemption.
And so just walking through the changes, this resolution was in the packet that was posted. There are minor red lines, which you'll see they have not, they're not depicted yet. So everything remains the same until you see a red line. Okay, there was a typo where this was inadvertently included twice. Here, this is a section reaffirming that the city council is considering that existing coastal resources are protected by discretionary design excuse me, that existing coastal resources that could be protected by discretionary design review findings as set forth in the municipal code are already protected by the discretionary coastal development permit findings as set forth in the municipal code. And a finding that applying discretionary design review findings to protect coastal resources is either duplicative of the CDP findings or unnecessary. Section now 5, so that's for the city council's consideration. Section 5 slightly modifies CEQA just because we have the new plans that were submitted. So there's intent by the applicant to submit an accessory dwelling unit potentially in the future. And so to avoid piecemealing arguments under CEQA, we are, for purposes of CEQA, considering the project to include the single family residence and the accessory dwelling unit, but only under CEQA. And so that has been updated.
So that doesn't put you in, I mean, it sounds like the applicant's on the same page as us, so there's not an issue, but it seems like, could that open up an issue with the HAA where you're basically having your cake and eating it too?
You really have to apply the statutory schemes that apply. And so we'll go through CEQA and it's what do we know? And it's really based about the applicant's intent. So we're trying to study the environmental impacts, knowing that there will be an accessory dwelling unit, but it's not at this time, and there's not a fulfilled application. There's not a fee. We haven't reviewed it.
It's not a housing development project.
not a housing
it's just an
development project.
environmental review for something that could have, so,
Just to avoid an argument,
Got it.
right, that we're
Okay.
splitting apart the project. And then I think the only other changes, if you scroll down, relate to the new conditions of approval. So these are the standard conditions of approval that the city uses. And then if you scroll down to the very end, there's number 25 would be it says the project shall comply with the requirements and the alternative materials and methods of construction prepared by DUDEC for the property, dated, and I think actually there's the new date, October 21st, 2021, instead of September 24th, or 2025, excuse me, October 21st, 2025. The project shall also comply with the requirements and conditions of approval set forth in the fire department plan review transmittal dated January 6th from fire marshal and deputy community development director and building official. Before issuance of building permits, applicant must submit a formal fire code alternative materials design and method request subject to approval by the city's fire marshal and building official to ensure the project complies with the existing building standards or state fire mitigation measures applicable to the development. And then 26 is the condition of approval that was agreed upon or agreed to by the applicant. Applicant shall reduce the plate heights and or perform additional grading within the building footprint to lower the structure into the hillside so that the roof ridgeline overall is reduced by a total of 4 feet.
Thank you. Any questions? Any other comments? Okay, then I will close the public hearing. And
I guess one thing to ask the applicant to come up now that we've reviewed all those red lines. and
Okay.
To get them.
then
to
I will
concur.
reopen the public hearing and ask Mr. Daenerys to come up. Derniers.
Anything's fine. Sorry, what was the question?
Bob's,
Do you agree to the?
do you agree to the,
I do. I agree in the sense that if this leads to a approval vote, then I will agree to them.
But so you agree to all the conditions as proposed on the slide there?
Yeah.
Right, everything that was in the
To
staff report
summarize-
with the red lines that were discussed.
To summarize, there was a CEQA modification to clear the ADU, whether or not it gets submitted as non-issue. Secondly was the 4 feet concession. And the third was the terms added under the stipulation by the fire department. Is that correct?
yes.
Okay. And yes, I agree with them all. Thank you.
Any other comments from our legal team?
None.
Okay, is that what you were looking for, Bob?
Yes, thank you.
Okay, great. So I will close the public hearing again. So public hearing closed, and I will ask for a motion. Do I?
I would move to overturn the design review board denial of the coastal development. Yeah, I would to overturn the denial and then overturning their denial of the coastal development permit and approve the coastal development permit and design review permits and finding the project exempt from CEQA with the resolution as was just shown on the screen and as agreed to by the applicant.
And for reference, that is attachment 2 in the packet with the red line.
The modifications.
Yep.
That's my motion.
Second. All in favor?
Aye.
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 Disagree? None? Approved unanimously. Thank you. Okay. Everybody okay? Do we need a break? Anybody? Yes? You're okay? Okay. All right. Now on to Appeal C, 560 Bluebird Canyon. Ready when you are.
All right, so this is the second project. Similar to the other project, it was part of the SB9 lot subdivision, and that file map has been recorded effectuating the subdivision. The project site is in the same location next door. The project is a new single-family home with a 2-car garage, and there is an ADU proposed with this project. We will be going over the background, contentions, CEQA, standards of review, the abuse of discretion definition, the city council options, and the staff's recommendation. In terms of the background and the history on this, the board reviewed the project several times. It was appealed by the applicant as it was denied, and it was remanded back to the board. And that decision to deny it the second time was appealed, and we are here now. Moving on to contention 1, same contentions as the other project. Jane will address contention 1 again.
Thank you. Contention number 1 is the same as contention number 1 from 1550. It states that the board relied on subjective standards in violation of SB 450 and the Housing Accountability Act. For response to contention 1, the Housing Accountability Act applies here because there are 2 residential units. It requires a inconsistency letter, and it also requires certain findings to deny or reduce density. SB 450 also applies. Both state housing laws have the Coastal Act carve-out. Staff's conclusions are similar to 1550 in that the discretionary CDP standards are required by the AJA and SB 450 under the Coastal Act. And that the city council should consider the subjective DR criteria only to the extent to protect coastal resources, not otherwise protected by CDP findings. Next slide. Okay. So the question for city council under DR, similar to the other hearing, do you find that discretionary CDP findings adequately protect all coastal resources such that applying discretionary DR is duplicative or unnecessary? For the CDP, what substantial evidence, if any, supports the DRB's finding for CDP finding 1, criteria 5 relating to the alteration of natural landforms? CDP 2, what substantial evidence, if any, supports DRB findings for CDP finding 1, criteria 6 relating to visual compatibility? And then in terms of the HAA, the city received plans, final plans on April 1st, as stated in the staff report, and the DRB identified inconsistencies in compliance with the HAA on May 22nd at the DRB hearing, which is recorded. However, in a boots and suspenders approach, the city council should consider under the HAA if a denial or reduction in square footage would have a specific adverse impact on public health and safety, and whether there's a feasible method to satisfactorily mitigate or avoid such adverse impact. Here, the slides are very similar for the very high fire hazard severity zone. I don't know if I necessarily need to repeat it here in this presentation tonight because it's in the staff report and in the written record. So I think that we can go ahead and move through these slides.
So same with the first project. Contention 2 is regarding the Southern California Edison power pole, and there is no evidence that the power pole would create a fire hazard, and any reference to the power pole on the basis for denial would therefore constitute a harmless error. Contention 3 is regarding the natural profile, the board incorrectly alleging the natural profile of the property is a coastal resource, and the position is inconsistent with state law and the city's own documents. There's no public viewpoint or ESA on the property as confirmed by city staff in the November 13th staff reports. And similar response here, exact same response. I don't really think I need to repeat that.
And if I may, just for the record, I think that city staff would like to incorporate the full staff presentation from the staff report or staff presentation on 1550 into the record for this 1560 project as well. So contention 4. The board alleges that the projects were inconsistent with land use policies, including land use policies 7.3 and 7.2, after the city was required to inform the applicant of project inconsistency under the HAA. As previously discussed, the HAA requires a written inconsistency letter. It requires findings to deny or reduce density. The HAA has a carve out for the Coastal Act, and those statutes must be harmonized. Questions for the city council relating to the HAA is, as previously stated, would there be an adverse impact upon public health and safety? And is there a feasible method to satisfactorily mitigate the above identified adverse impact finding? As previously discussed, the applicant submitted revised plans on April 1st. The design review board identified inconsistencies within the time required by the HAA at the May 22nd public hearing. The HAA does require a written letter from the city regarding noncompliance with specific standards. Although the meeting is recorded and a transcript could be generated, so city staff believes that the requirements of the HAA are fully met. That's the city staff is also recommending that the city council consider these specific adverse impact findings as a boots and suspenders approach. And then contention 5 relating to the board improperly excluding the ADU, that appeal contention does not apply to this project. It applies to 1550 Bluebird Canyon Drive.
CEQA, same thing here. The decision to uphold denial would be considered exempt. If the appeal is sustained, you must determine if the project is exempt pursuant to section 15303 for new construction. And here are the standards of review again on the next 2 slides, as well as the abuse of discretion definition and options, same options and same recommendation.
Questions of staff? From council? None? Okay, I will open public testimony and give the applicant 5 minutes for a presentation.
Can you put up that video, please? Let it run before we start.
Do the video, please.
If the board could turn to that document I provided on page 28. So this video, it really kind of can show you the perspective of the homes with respect to Culver's and Riahi's projects next door. And you can see there's a tiny sliver of view that actually is pointing directly at Catalina from the first floor of my home, right? Now that first floor is at a 9-foot plate height already. It's already limited. And that's the only view from my patio that I have to Catalina. Now, even that lowering of the lot A by 4 feet doesn't address that because the roof line in the lower floor is only around 513, which is about the same height as Culver's home. So we don't have the same options to lower the home on that side. The second floor ADU, its height above the street at the entry, which is 467, is roughly 48 feet to its highest point on the hilltop for that ADU. And the entire upper floor, the second floor, is an ADU. And that, well, with the exception of about 150 feet of a loft area for the lower floor, which is projected in the front there. That particular home siting has been the same for the entire time. We don't have the same options that we do to make changes to this one. And because the hill's sloping up consistently, there's about a 10 to 11 foot vertical height difference from the west side of the Lot A property to the west side of Lot B property. That west side Lot B property is at 505 on grade, exactly where that first floor is cut into. And on the second floor, it's on grade there. Actually, it's 1 foot above grade.
Can you guys stop the animation? I'm getting like nauseated.
Yeah, just pause it, excuse me.
Thanks.
So the big changes we made since you saw this at the appeal on August 12th is that we removed all the structures from the right-of-way. We pushed it back onto the property and actually underneath the garage by about 9 inches and cantilevered it. Now, this actually removed all of the improvements that we had added for the May review as provided by feedback from the board and the neighbors that they wanted to mitigate the impact of the retaining walls. And by the way, on both properties, our maximum retaining wall height, in its totality, prior to this version was 12 feet. Now it's 16 feet on both lots because we pushed it completely off of the right-of-way. But we believe in good faith that that was the right change to make. I think the future expansion of the street makes sense. And I don't want the neighbors who have existing encroachments in the street to be the ones who pay that price. But unfortunately, with the Edison projects now installed on site, those would have to be undergrounded by the time that's been dealt with. So while the majority of the home is identical to what was in the May 22nd DRB review and the August 12th council review, the front part of it and the right-of-way has addressed it to remove the need for the REP. And the only requirement now is to really address the CDP. And ultimately, this is not a natural landform site. It is a graded road from back in the day, and it has been terraced exactly per hillside guidelines. More importantly, the front half of the property requires both a turnaround, that's per city code. We cannot have the garage backing onto the street. It has to have a nose-out turn-in because it's a through street. And that turnaround and the garage take up the entire front half of the property. The only place for a home is on the top of the hill. And if we lowered the garage and the driveway down and lowered the home down, we would double, if not triple, the dirt export. And on this site, on this home, and like on the other one, roughly 250 to 300 cubic yards of additional dirt would be required for every foot we lowered it. So I don't have the same opportunity here to lower this home, but it is on average less than 11 feet above grade for this proposal. And it looks higher because it's higher up on the hillside, terraced from west to east. The ones, Cover Homes and those, are terraced from north to south up the hill. And we have different conditions on our property because it's a different property topology. Thank you.
Thank
if you.
you.
Have any questions, I'm available.
Speakers in support of the appeal?
Thank you. Good evening again. I'll be very brief on this one. We agree with staff that SB 450 and the HAA apply to this project. There's no public health and safety issues. The project meets all applicable objective standards. And I will incorporate my prior comments that I made on 1550 on coastal resources into this project as well. Thank you.
Thank you. Any other speakers in support of the appeal? None. We'll move on to persons in opposition to the appeal.
Thanks, guys. Good work on the last one. Lot to go through there. A lot of crazy stuff. I don't understand any of it. So on this one, I assume that we're probably going to be talking about conditioning the home to lower as well. I know he mentioned he can't do it, but keep in mind that we're talking about David that is literally blocking his own views with the house that he's building right in front of him. Okay. So the maximum, and I'm going to kind of talk a little bit about something too. We talked about my max height being 515. I think that's actually wrong. We're actually only at 513. And the reason is because we were conditioned to go down 2 feet on our roof line when we got DRB approval. And I don't think that was reflected in those notes. So we are a little bit lower than that even. So our ridges, my max height on my lot is 513. He's right next door to us on this one, and that's at 514 is his max lot. Our house again goes to about 513 feet high, which is basically at the top of that ridge line, just crests right at the crest. His house though, goes up to 525 to 526, including the ADU, which I understand I'm not sure we're able to even talk about that. So a full 11 to 12 feet higher than where we are, currently kind of conditioned for that ADU. So just keep that in mind. So for the elevated decks as well that are west facing, that finished floor height is 516, has glass railing, that puts up to 519. And so that's 5 feet higher than the max lot elevation. Comparatively, our west facing deck is at 503, which is 7 feet lower than our max elevation on our lot. So again, big differences here when we're talking about compatibility, like you guys were doing in that last one. And then when it comes to the street to roof height, even though his height comparative is similar to ours, so we're talking about that 48 feet or whatever it was going from the street to the roof. Okay, the big difference is that for our project, we go back 57 feet to our nearest roof. We terrace it back like Hallie had mentioned. All right, so 57 feet. His nearest roof to the street is like 22 feet. It's less than half of how far we go back. So obviously from a compatibility standpoint, from a view standpoint, from a look standpoint, that's going to mean that it's going to look a lot more imposing on Bluebird Canyon Drive simply because it's much closer to the street than ours, which is pulled back when it comes to the roof lines. Thank you.
Mm-hmm.
Hi, me again. I just want to question something. I live at 1545 Bluebird Canyon Drive across from Sue's house at 1540. And when you go down into my living room, I'm almost 2 floors down below Bluebird street level, and I have a whole south-facing view, and I can see Catalina from my house. So I don't understand when someone's up on a ridge that they can't see Catalina from the south-facing view. It doesn't make sense. Thank you.
Next speaker, please.
My name is Pamela Adams, and I live on Morningside Drive. I continue to oppose this project, Lot B, on this agenda. I'm asking you to uphold Design Review Board's denial and return this project to the applicant. This lot, both lots actually, are south-facing lots. They're not north-facing lots. And these two projects, this project has had its original lot cut in half. And this new design is overdeveloped and is just massive in scale and bulk. This design also sits on top of the ridge line. and instead should be nestled into the graded land. I am asking you to return this project and back to the applicant to redesign, keeping in mind past DRB recommendations. I'm not sure if this project or the other one had met with, you guys had seen, and also the neighborhood suggestions were not considered. Thank you for your time and consideration.
Thank you. Next speaker.
Many of the same comments I made on 1550 apply, so I will not repeat those comments. I would like the council to address two things. Number one, the retaining walls. Retaining walls are not staked typically, and of course they're not staked here. One component of the incompatibility with the neighborhood are these fairly continuous retaining walls. And in addition, what has not been discussed are the uphill retaining walls on the uphill side of the driveway. And this is both of those contribute to being a fairly continuous retaining wall situation broken only by the driveways. So I'd like council to address that as part of their deliberations on the design impacts of the neighborhood for incompatibility with neighborhood. Secondly, I would like council to address the issue of the lack of road improvement plans, and particularly on sheet A00 of this set of drawings. There are road dimensions that dimension a half road. The municipal code does not permit half roads to be constructed. And if the minimum road width is 18 to 20 feet, we don't have 18 to 20 feet as it's shown on the plans to date. We have the center line of the road and a dimension from the center line of the road, but in some places on the south side of the street, it's maybe 6 feet. So I would like the council to discuss the road improvement plans, because once the road improvement plans are made, the plans may change. The plans may no longer, the driveway connection may no longer work. The grading may change. And that's an unresolved issue. How is the width of this road going to be established? Because it is not established right now. I urge the council to deny the appeal. Thank you.
Thank you. Next speaker.
Mayor Orgill, members of the council. I won't repeat, as people have said, I won't repeat what I mentioned previously as the projects are similar, but a little bit of food for thought. For Lot B, I think visual compatibility is still a topic that we should be considering. And I think as you're deliberating, I would ask that you put weight to the other homes in the neighborhood. For example, there were 15 homes that were identified for the basis of looking at floor area ratio submitted by the applicant. We're looking at the cover home, which is, I understand, precedent as something that's recently approved, but it's not actually precedent because it's not built. It was approved, but it's not built. So the integration, it's not integrating with the existing neighborhood if you're not comparing it to what already is there. That's by definition. Lot B by definition is taller than Lot A. So if we're talking about reductions on Lot A, I would also ask for the benefit of the neighborhood that we look at reductions for Lot B. Even though it wasn't mentioned, I think on this project, the sort of the at-grade garage study, but if we think about sort of the height of the actual structure, the way that we're getting to these very tall levels is the fact that the garage is elevated. So that delta of 15 or 17 feet from grade to the bottom of the garage finished floor, that's what is really creating this five-story office building structure. I would ask you to opine on if you have seen or the city has really received an earnest study about what would happen if we brought the entire house down. I know it's been cited that it would create a variance, but I don't think the variance alone should be the basis of denial if it's in the betterment of the neighborhood. And then two more things, in terms of the views, our house is very similar orientation to Lot B. We sit about 50 or 60 feet down vertically. We have tremendous views of Catalina, the ocean. We're very blessed. And I don't think that, this siting of the house would be fighting for views. And then the last topic is, in terms of Bluebird Canyon as a destination or a public resource, I don't know what the definition exactly is really, but if you think about, if you surveyed residents, you surveyed visitors, a lot of people hike, they bike, there are e-bike tours that go up there specifically for the beauty of the canyon. So I do view that as a public resource. Thank you.
Thank you. Any other speakers?
Hi, William Warner at 1565 Bluebird. I appreciate that we're all working on how these standards apply in real time. That's difficult, and grateful to council for weighing these considerations carefully. Same concerns apply here to this project. I won't repeat those around siting, kind of null top impacts. Given that council just required 1550 to come down to 9 feet over the ridge line, the Cover home being only 2 feet above the ridge, I'd ask for consistent logic and application of standards to this project as well. On the point about kind of potential view impacts to 1560 in doing this, kind of that argument doesn't seem to really hold up. The project would still have ample views. I know all of us in the neighborhood who are across the street and considerably lower both have south-facing views and an aspect of west-facing Catalina views. Yeah, so I do think the same path forward exists. I ask you to uphold thank you.
Thank you. Are there any other speakers in support of the appeal? None? Okay, then we'll have the appellant's rebuttal.
Presentation, please.
Put up the presentation again
And go to page 40.
and go to page 40.
Okay, so the highest point on Cover House is at my house with respect to the street below it. The maximum height on both properties is 50.4 feet. That's from the plans as submitted today, right? There's no doubt about that. You can go verify it. Go to the 2 more slides ahead to page, 3 to page 43. This is the relative projection of the Cover House from the curb with my home overlaid on it. They're almost identical. Now, at the end of the day, they can talk about articulation on the hill being poor, but relative to Cover's, we're identical. And more importantly, this view claim, we have no view below the ridge line. When you're down in below 503, which is the west side property there, you're staring at the back of the hill. You have a peekaboo view of the ocean, none of Catalina, and you're staring at that peekaboo view of the ocean through now 3 power poles, which were raised in height by 4 feet by this upgrade, which I did as courtesy to the neighbors to bring all of those wires to the north side. I granted 2 easements for that. I'm also going to point out that, go to the last slide in the deck, that these claims about the road are not helpful to the neighbors. The road is narrow because of encroachment by the neighbors on the south side. Any future remediation on this center curve will be on that south side. And our applications, both sides, both Lot A and B, to where we can push our driveways and parking in as far as we can, about 5 feet off that right of way. But more importantly, we do not require an REP. We've cleared out any improvements. So if it does need to widen on the north side, once those poles are gone, you have the entirety of it, and you need to make no changes on my property, nor Lot A for that matter. So, at the end of the day, I still, regardless of this process, respect and want to protect the neighbors' interests here. Thank you.
Thank you. Does staff have any comments regarding the rebuttal? None?
Staff might just point out, because plate heights were discussed for this project and the prior project, 1560 Bluebird Canyon Drive is designed with plate heights that range from 8 to 9 feet, 8 feet at the garage level, 9 feet at the middle level, and 8 feet at the upper level.
Thank you.
What about like the den that was referenced with the ADU? What was that about?
What I might do is share a cross section of the
I think it was a loft, wasn't it?
The loft, that
Building.
was what the, yeah.
There is some articulation in the height of that roof, which I will walk the council through. Just to orient the city council, Bluebird Canyon Drive is on the left-hand side. Down here is the driveway apron leading up to the garage. On this level here, we have an 8-foot plate height at the garage. At the main living level, directly above that garage level, we have a 9-foot plate height and then an 8-foot plate height at the ADU floor level, the uppermost level. And here, just beyond that ADU deck, this is where we have that 8-foot plate. And as we extend beyond the ADU bedroom 2/office, the ADU roof again angles upward and appears to attain somewhere in the order of 11 inches to 12 inches of additional roof height at that upper level.
Okay, that's helpful. Question for the fire marshal, and maybe, I don't know if Public Works is here, but so the housing account, obviously public safety is our number one goal. Housing Accountability Act creates an exception if we can show that there's adverse impacts on public safety. Is the testimony that you provided about the first project the same here, where there, in terms of the road fire access? Can you speak to that?
Yes, thank you for that question. So the road conditions do apply to this property as well, and the exceptions. With regards to the center line, all those comments that I heard earlier, when it comes to fire access or fire response, the way that fire department, of course, utilizes the road during emergency response is the entire road. This road is not a divided road per se for us when we respond in emergency. So we utilize the road just as we would responding to existing homes. So a center line doesn't really draw any special condition for us. We will utilize the entire street itself. So therefore, the condition of the road as it is will suffice for emergency response.
Okay. And then this kind of to Susan's question, I don't know who this would be to, but like she raised the issue of if road widening were to happen in the future, how that could, impact the site, or I don't know, Anthony, did you hear that? And can you respond to the specific comment that she made?
Yes, thank you, council member. The city did carefully review this project for compliance with applicable development standards, both the zoning standards that would apply within the property limits as well as street design standards. The city's access requirements in the zoning code require that an applicant approve a street along their property frontage measured along the front lot line up to the street center line. And in this case, what we did is we reviewed the site plan, the grading information, and all additional information provided by the applicant to confirm compliance with the street design standards, again, from the center line towards the subject property. Based on the street type here, the street is required to provide a 10-foot travel lane. The proposed project does provide the minimum 10-foot wide travel lane across the full property frontage. There is also one on-street public parking space that's being provided by the project as also required per code. When a vehicle is parked in that space, it would not encroach into the 10-foot travel lane. There are encroachments that exist on the other side of the street those are encroachments associated with development across Bluebird Canyon Drive. In this case, we're not processing a subdivision application. If this were, say, like a tract map application where a developer might control both sides of the street, the city staff's expectation would be that the minimum street improvements would be provided across the entire right-of-way from lot line to lot line, whereas here, this project is subject to street design requirements that apply only from the center line towards the subject property, and staff did confirm that the project does comply. We also carefully looked at the grades from the street towards the driveway, confirmed that at the property line, there is not a grade break such that a vehicle cannot safely enter the project from the street. The driveway slope also conforms to minimum standards, so staff is confident that the project is meeting minimum requirements.
So if I had to consolidate that response, I believe what Susan was saying, just to, maybe this might make it a little bit more clear, is the grade difference between the street, the end of the street, and the right-of-way. She's insinuating that there's a grade difference that might interfere with any future widening of the street because of that variation. Is that, Susan, I believe that's what she was saying.
Yes, I think so too. Yeah, so staff looked at this closely. Once the applicant was required or asked to bring back the project out of the right-of-way, we looked at what this driveway would look like in the event that the street was widened, and looked at the Public Works standard plans as well as their parkway improvements and the driveway apron to line it up, so that it would line up essentially.
Thank you. Any other questions, Alex?
So is the street, on this half of the street, the applicant's side of the street, being widened to the full extent of the right-of-way?
Yes, so on this side of the center line, the applicant is providing the minimum required 10-foot travel lane.
That wasn't my question. Is it being widened to the full extent of the right-of-way?
No, it's not being widened to the full extent of the right-of-way, which is
That is correct. Daniel is correct. There will be a sloped area that's existing. They're not grading along the full length of the property frontage within the right-of-way. The proposed project provides the minimum 10-foot wide travel lane, and at the edge of that travel lane, there is a 6-inch curb, and there are areas where there would be perhaps a 2-to-1 slope. The city could, in theory, in the future, propose a road widening project either within the existing alignment or a potential realignment, and that would have to consider not only these two properties, but properties uphill and downhill along Bluebird Canyon Drive.
Are there hardscape improvements beyond the road edge, I'll call it the road edge, that this project's going to construct that would allow for passage of a fire vehicle?
I might ask the fire marshal to confirm, based on his review of the plans, if he identified any such obstructions to fire apparatus traveling down Bluebird Canyon Road with the project as currently designed. I will point out that here we have the proposed street widening, 10-foot wide travel lane. This is the 8 by 22-foot wide parallel parking space. That's the public parking space. And at the edge of that 10-foot travel lane, it would terminate with a low, perhaps 6-inch curb, or a rolled curb, excuse me. The overall road width would vary between 18 feet and 20 feet. And so I suppose the question of the fire marshal is that sufficient for fire apparatus to travel down Bluebird Canyon Drive?
Yes, it is.
Okay, thank you.
Okay. Did you have a question, Alex?
No.
Are there any other questions of anybody from the public or staff?
I have a few questions of staff. I'm going to refer to Susan's questions. Am I understanding correctly that there will need to be a future plan for roadway improvements, or is the only plan that is required what we're already seeing as part of the project?
There are no additional city requirements that are not being identified and planned for with this project. The project is providing the minimum street improvements along their half of the street, essentially.
So the only thing would be if in the future the city decided to improve the road, how is that impacted by this development that we're looking at tonight?
Correct. And at the prior city council hearing on the Bluebird appeal, the city council directed the applicant to revise the project such that there would be no non-conforming conditions created if the city should pursue some type of a street improvement within any portion of the city's right-of-way along the property frontage. And the project has been redesigned accordingly.
Okay, thank you. Just one other question. The retaining walls that one of the members of the public said are 16 feet. Can you provide any insight on, is that standard in this neighborhood? Do we have other examples of retaining walls of that height? What can you share with me about that?
Yes, if you give me just a moment, I can actually pull up the plans for 1536 Morningside Drive, which has been entitled by the city council.
Can I ask a follow-up question sort of related to that? So do we have, and maybe this is something that we need to think about in the future, like an objective standard that you're getting that, and maybe that's helpful in the context of thinking about this project, but is there like a standard in place that we could, that we have about like how high retaining walls can be? And if not, is that something that could be a standard in the future for future projects?
Yes, that is a standard that could be developed by city staff and proposed for city council's consideration, but it does not exist.
There's no
today.
standard right now, so you could have as big of a retaining wall as you want. There's no objective standard.
There's no objective
related to
standard.
retaining walls. Okay.
That is correct. And so what we are looking at here is grading plan information, again, for 1536 Morningside Drive on the other side of the Knoll, the Covert project. And if I zoom in here, this, as the council may recall, is a garage floor level. There is a turn-in garage, and that, what I'll refer to as like a mini motor court, is supported by retaining walls on two sides. Here dashed in, I believe these are stair steps providing fire access. There is a retaining wall here shown in gray that is running roughly parallel to the street, Morningside Drive. And per this plan, that retaining wall has an exposed height of 15 feet. There is also additionally a wall that I believe is taller. It's also a retaining wall that's perpendicular to the street. And I believe that is not shown on this section, but I can also point that out as well. But it preliminarily just want to mention that there are other tall retaining walls in this neighborhood, either existing or in this case, entitled by the city council, and staff expects will be constructed at some point in the future.
Okay, thank you.
Any other questions?
So a couple more. So like, I think another standard we could think about in the future, but again, we don't have in place here now, because I think to the point that Susan's making is that, we have the right to take over the public right away, right? And that was the issue before, was that there were objects in it where it would potentially get in the way. Now that doesn't exist, right? And maybe in the future we could look at in areas like this where you have where there's a need, it's a constrained street where there's ideas of widening in the future, making the applicant actually do that as an objective standard, and kind of in that same line of thinking with respect to like undergrounding the poles. Is that something that we have the ability to require that the applicant do, Or is that, do we have a standard in our code that would allow us to do that? Like that are in the easements that he gave, is that something that we have the ability to do?
If I'm understanding the question, the new development or major remodels are required to underground their electric utilities. Now, if there's a utility pole that's servicing not only the subject property, but others, the pole would not be undergrounded with that project.
And so that would, okay. So we wouldn't be able to do that here. I think those are my only.
There are some areas that we have tract maps that do call out for specific improvements such as sidewalks, curbs, street widths. This is just unique in that we're dealing with the tract map that's in place.
Based on objective standards.
So I think some of your comments we could evaluate them at a future date.
Yeah. And those are all my only questions for staff.
Okay. Any other questions for staff?
One of the contentions that the counsel for the applicant has here is that this hearing actually violates the 5 hearing rule in the Housing Accountability Act. Could counsel speak to that?
Yes. So under SB 330 or even single family residential projects, a city is limited to holding 5 public hearings on a project. Here we have a situation where the project has been significantly revised over time such that it really has been a different application. So for example, if you go back to the background slide, the original project, which did not include an ADU, was submitted in January 2025. Then in May, so that's, several months later, a revised project is submitted with a new ADU. And then in June, in November, the second revised project occurred without the REP. And so our position would be that, given that the application has substantively changed and new triggers for coastal development permit have occurred with the addition of an ADU and entitlements have been removed, that the 5 hearing rule has to restart over with such revisions.
So, but Madam's Assistant City.
Let me just follow up on that, Alex, if I could. So this would be the 5th hearing subsequent to the submittal of a completed application, including an ADU. Is that our position?
So with the ADU, and I think I would argue that we would count from without the REP, which the DRB held a hearing without the REP on November 13th. And then this hearing is without the REP, so that's 2. But if you track back to the revised project where the ADU was also included, the DRB held the hearing on May 22nd. And then the city council had its hearing on August 12th. And November 13th was when the DRB considered it. And this is the city council's hearing on the project tonight. I missed when the DRB adopted the first denial resolution. So this would be the 5th hearing tonight since the ADU was added to the project.
Okay, thank you. And the reason I asked that is, there was some suggestion in some of the testimony that we, remand this or extend this to another hearing. We don't have that option.
No, you do not.
Thank you.
I was just going to add on to that. I recall at the meeting, the last time this came to council, I think we had the applicant confirm that was hearing number 3, right? Because we wanted to be intentional to make sure we were on the same page so that if this project were denied, that we would have the last bite of the apple. So I recall the applicant agreeing to that at that hearing.
That's exactly right. And then that is why the city council directed the DRB to have 1 hearing only.
Correct.
Any other questions of staff? Okay, well then I will officially close public testimony and bring it back to council for deliberation. Anybody want to jump in?
It seems to me this project is somewhat different than the last one, right? Because the HAA applies and, we're at the fifth hearing. There's another contention that the applicant and through council has made, which is that there was not a consistency. The city did not note inconsistencies in the application within the required 30-day period, and that would extend to our deliberations on the CDP. What's the city attorney's position on that?
Well, I think that under the HAA, even if you even if you do not issue the inconsistency letter within the time frame, and then you are deemed consistent with those provisions, the city council still has the ability to deny or reduce density or square footage on a project if it is able to make the specific adverse impact findings. And so really a question then becomes, let's consider arguing, arguendo that it is deemed consistent. There's still, you would have to make the specific adverse impact findings in order to then deny it. And those are burdensome findings to make under the HAA.
So one of those is public safety, but we've heard kind of extensive testimony from our public safety officials that there's not a fire issue. What would be the other basis for the finding, requirement for a finding?
I think that the fire code provisions would be the basis for public health and safety standards.
Okay, so I don't know. It seems to me that under, Alex, you commented earlier on the other application, we have to apply the state statutes as they apply to the project. Notwithstanding how we may feel substantively about the project, it seems to me that I can't make the findings of, to override the HAA here. So I think in my view, we are compelled by state law at this point to approve it.
Any other comments?
So just to follow up to clarify, so even if in theory we could make, an adverse impact finding on coastal resources, that would not really be allowed because the HAA, there's sort of a narrow exception limited to public safety, and the testimony from our public safety officials who we rely on for that had pretty, compelling evidence that that was not the issue here.
Correct. Okay. There's no case law right now that analyzes whether a coastal resource or the Coastal Act, for example, falls within a public health and safety standard. And so we know that the fire code is a public safety standard.
And so because of the HAA and the consistency determination that didn't apply in the last one, our hands are even more tied on this, just to summarize.
Correct. That's
okay.
A fair statement.
Any other comment? I'm going to open the public hearing and ask the applicant to come back up to the. So you've heard several council comments, and I just have a question for you. Given what was said in the current conditions, is there any appetite for trying to concede, as we did on your other project, to lowering the project several feet?
Well, a couple of problems with that. One is cost. I'm out of pocket incredible amounts of money on this, and each change set cost me tens of thousands of dollars because it's not just the architect, it's the engineering and all the processing. Just these appeals cost me $5,000 plus all the other ancillary things. But secondly, this is actually my home, and that ADU, which I wasn't going to do for 5 years, but that ADU is where my wife and I are going to retire. And I'm having one of my kids move in downstairs in a few years. So the bottom line is, I would like to say yes. And the only reason I would agree to it, and it would be very minimal, is because the Ramita family, who owns the property to my east, had asked me to try to consider further reduction but they've constantly been supportive of this project. And the only ones, really, of the neighbors that has been, right, consistently supportive. So to the extent that we could find like 6 to 8 inches or something on the roof, possibly, I would have to talk to my architect to see if it could be any more. But just to put it into context, 1 foot of lowering that house on that grade is about 250 cubic yards of earth increased. So if I was to consider anything, it could really only be maybe the roof slope or something on the top of the building, because the lower floor is 9-foot plate heights, and basically that's because we have to have a view corridor out that little tiny sliver of a patio window to see Catalina, and having an 8-foot plate height there would just be untenable because of the large distance that covers. And the upper floor is already 8 feet. So those combinations of restrictions really limit how much I could offer. But, in good faith, I could try to find a way to bring that roof down no more than 1 foot, right? That's it, all I can offer. And just as a good faith consideration. Now, I can offer other things, like I could take responsibility to lead the effort for the assessment district to do the undergrounding for the entire neighborhood, because I'm very effective at dealing with Edison and others. And I could do those things. I could do other things that benefit the neighborhood, but you can't ask me to really materially change the height of this house any further. It just doesn't work.
While you're up here, okay, I was just going to say, are there any other council
No, I
comments?
was just going to say, David, so I think Eileen came up and said, so I used to own the house. I built the house at 1545, which is significantly lower than Susan's, but I can tell you for a fact that from the living room, which is down 2 flights of stairs, I could see dead on Catalina from there. I mean, I'm way lower than that house.
But you're further projected out and you're not blocked by this hillside. This hillside runs toward the southwest. And as soon as you drop down below that 503, 505 level, you can't see anything except for this tiny little sliver of ocean view. And it's now studded with 3 big power poles. There's literally no view of the ocean from that spot, and certainly no view of Catalina. And, obviously, we didn't put Catalina in that 3D view there, but we've done analysis to show that. And the only view I have, even on grade with that lower floor, is through that sliver between the Lot A building and the Covers home. That actually goes directly at Catalina from that patio. And it was designed exactly like that to at least bring that view into the interior of the home. Beyond that, that's it. We don't have a view of Catalina at all, and barely any of the ocean.
Has the project been designed to minimize the retaining walls? Is there any way to improve on those?
So that is what we did for the May 22nd review. We actually terraced up the retaining walls, made them no more than 6 feet in height where we could along the driveway and all that. But once we were required to move that driveway completely off the right of way, we really didn't have that option anymore. And ultimately, the cross section of the Cover property you saw there, that's actually a pretty conservative height of that. In some places on the far side, it's nearly 20 feet of that retaining wall. So we don't really have an option to reduce the visible retaining walls, because what we could have done, we've already done on the upper part of that driveway. And, I've stressed about this extensively and modeled this all with Toll to really figure out exactly how I could put that driveway in, and it barely fits. That's why we really didn't have any options for making changes to this project compared to throwing the other one out and starting with Horst on a new one. So to the extent that we could have reduced its retaining walls, they are about as where they can go. They really can't go down any lower.
David, could you put that landscaping, that waffle pattern with the landscaping to cover those walls? Like you did on your other house?
So I would like to say yes, but here's the problem. And this is the case on the other lot too. There's going to be some part of that at the bottom that's actually fixed retaining wall because it's the anchor for the caissons below. We have to go down 12 to 14 feet below the street line to shore up the hill, which we would have done a lot more of that if we had been able to do this last May before those poles went in. But that lower part has to be kind of a fixed cemented retaining section. Above it, there are some parts in there where we could probably make some adjustments to do that. But our intent is already along the top of that, because there's kind of a small terracing area, is to put vines in there and have them drape down along that back there. So we should be able to cover almost all of that lower part with vines that are effectively hiding that mass.
Is that in your current landscaping
Yeah,
plan?
it's actually in the model. You can see it too. Could you put it up for a moment if you have it? Bottom line is that was the intent for both properties. The what's it called? The wall for Lot A? The crib wall on Lot A effectively would look very similar to the vine model on this one. And you can see that right along the top edge, we've got basically a recess of about 1.5 feet to put in planting at the top there. But we don't have the vertical space to push it back. That wall type requires not only height, but vertical depth to get that stacked look. We don't have that there. We would have to go further underneath and cantilever out the garage even further.
So that's not feasible is what you're saying?
No, unfortunately.
Yeah, the crib wall is not vertical.
This might be a question for city staff, but also kind of, it'll go to you next. So the way we do it here, so your conceptual landscape plan, that's approved as part of these entitlements, and is that accurate? And then, so like, if there's a final landscaping plan, right, in the construction
There will be a
drawings
final one, yeah,
phase.
but
So,
not yet.
so are you open to having, because I think there's a shared goal here, right? Like, you want to make your property look as good as it can be, and the neighbors want it to look, to mitigate the impact of the retaining walls, to have some sort of I think it's already conditioned the idea of, you have to get your final landscaping plan, but if there's a way for some creative ideas that could be a collaboration made between the city's landscape architect and your landscape architect as you
I'm
move
open.
towards that. Yeah.
I'm open to any
Just
of that.
to figure out like a win-win solution that can really mitigate the look
Yeah.
of those walls.
As a
Nope.
condition of approval, I'm open to any.
You are, okay.
Any other questions?
So it sounds like you're willing to go down 1 foot.
But not an inch more. I might not even be able to get a foot. It just depends on a couple factors on that roof line there. That roof line was very difficult to design.
Okay.
We will try, but look, I got to tell you, one of my biggest mistakes with both of these projects was that I tried to put forward the absolute best and most conservative project I could. This is a very difficult site, given that it starts 10 feet above the street. So it's already been squeezed pretty hard, and I'll do as much as I can.
Could we get to a 9-inch guarantee and then you'll
9-inch
get to a fee?
guarantee. I heard some laughing back there.
I don't think at a council meeting we can say, under these circumstances, I'll do my best efforts. I think we need to have something concrete
Yeah,
here.
you can propose something, but just remember, this is the home I'm going to live in. I don't want to walk around in 7.5 foot high,
Yeah.
ceilings, right? I'm a tall guy.
Can you agree to 10 inches?
I
Not
would
an inch
agree
more.
to at least 10, possibly a full foot.
And good faith to get to the final, okay.
Correct.
So I heard that you said, just to confirm, that you'll agree to 10 inches reduction and you'll make good faith efforts to get to a foot.
Yeah.
Okay.
And really, this concession is for the Ramitas.
Okay.
Because I promised them I would try.
Okay, and then you'll agree to, and we can maybe work out the language and get your confirmation, after as part of this, but for something involving collaboration with the city's landscape architect to figure out how to mitigate the impact of the retaining walls as part of your landscape final plan.
Yeah, we will take another pass at it. And our landscape architect is Michael Wilkes. So obviously ex-DRB member, he knows some of the factors good. And of course, Steve Garotani is a consultant on this project. We will work with the city, as long as it's a collaborative thing, not a over the fence and a month later we hear back kind of thing.
Okay.
Right? Does that make sense?
That makes sense. I don't have anything else.
Any other questions? We'll close the public hearing, bring it back to council.
I have one
Okay,
just general offer to.
open public
Oh,
hearing.
he has another offer. Okay.
Look, I want to make sure you understand that I really care about the neighborhood, right? And if you look beyond the current immediate approvals here, or the denials, if you call them, the future widening the street is inevitable. I agree with that. And where my property is, there's now 3 poles. Eventually, they're going to be undergrounded. And on the edges of my property, to the west and to the east, is these areas that are very tight. And on the south side, there's no way to widen there. So they're going to have to be widened on the north side. And that includes Susan Witten's southeast corner where her driveway is. And if you applied that REP condition to mine, that you did to mine, to her, she would have a 5 to 7 foot grade break at her property line. So how are you going to solve that? Well, one of the reasons why we've been adamant about not changing that driveway on Lot A and its access approach is because the only logical solution in the future is for Susan Witten's property to share that driveway to allow that street to be widened. And I can stipulate that we can put a rider in the Lot A project to say that it will be considered for some consideration to eventually share that driveway if it's requested and required, which is, I think, an important concession for the city and the neighbors. Does that make sense?
Yeah.
I hear what you're saying. I'm just not sure if that's something that could be,
We'd have to do it on the other.
yeah.
I'm looking for alternate ways.
Susan Whiten's driveway.
Yeah.
Yeah, correct. Mr. Mayor, I would advise that this kind of line of thinking in terms of future property owner probably isn't best suited for this time,
Well, and it's
irrespective of the offer.
Well, only because I'm
project,
selling that
too.
lot, and once it's out of my hands, there's no deterministic
Okay.
ability
Right.
to use
Yeah.
that driveway.
Okay.
Understood. Okay,
Thank you.
any other questions? Close public hearing. Bring it back to council.
It sounds like the most we were able to get was he agreed to 10-inch reduction and good faith efforts to get to a foot. And then I don't know, maybe we can figure out what the condition about collaboration with the city's landscape architect to mitigate the mass and or the appearance of the retaining walls as part of the final landscape plan.
So the question is, how do you incorporate something theoretical into a motion?
Well, you can have something like that where it's.
Yeah,
it's
I'm not
good,
saying
yeah,
we can't do it. I'm
but
just,
yeah.
that's what we have to figure
How do
out.
we draft it and what are the specific?
That's
terms?
why we have smart
Yeah.
legal people up here.
Why can't he, the city's landscape architect, if he has, why don't we just put it in the motion and
Well, 'cause I-
Michael Wilkes has to do it?
I think the idea is that that the city landscape architect could give feedback to his landscape architect as part of that process.
If I may, I think, Anthony, if you want to pull up the draft when you're ready, the draft resolution with the red lines. In terms of the landscape plan, I think that the city council could consider a condition of approval similar to applicant shall mitigate the impact of the retaining walls with crib walls or other landscaping measures subject to final approval of the community development director. And then in terms of reducing the roof line, I think, Anthony, you could probably borrow the same language that was from 1550 and instead of 4 feet, put 1 foot. I will suggest 1 foot just because there is another condition of approval that's standard in the city's resolution that states that in the event any of the conditions of approval are infeasible, the decision-making body hereby authorizes the community development director to modify those conditions in the most conservative manner possible in accordance with the limitations of the city's municipal code to allow for completion of the project. So I think that's for the applicant's consideration because I think, best efforts gets, I think, a little confusing and then we can all walk away and understand. Okay, so Anthony, maybe you want to just pull up that resolution at your convenience.
You never know.
I'd like to just say, limit it to 10, because it's very difficult. I personally try to make.
Well, so I guess we'll put the conditions up and the applicant can agree to them and okay. Madam City Attorney, while he's doing that, do you think it would be, I mean, I think that for me personally, it's taken so much time to just understand all these different laws that are conflicting and complicated and very nuanced. Just for the benefit of the public, could you sort of articulate how what the consequences would be if we hypothetically took let's say that we took the position that there was a visual resource from a CDP perspective and we denied the project on that basis? Could you articulate what the consequences for the city would be, and also in the context of the inconsistency determination question for the HAA?
Sure, that's a great question, council member, and I think it's probably helpful to I don't know that we've completely clearly stated how this is different than the last project. And so I just want to be very clear about that. So the last project, as we said, was not an HAA project. It was a single unit project. This is an HAA project. This is a 2-unit project. And so the rules of the game are different. And to that end, they're different actually in quite a few ways, but one of the issues that the applicant raised was whether the city sent an inconsistency letter within 30 days of the date of, within 30 days of completeness of the project application. And the city certainly believes it substantially complied with that provision. Within 30 days, it gave notice of those provisions. However, the Housing Accountability Act has a provision that requires a court, if the city is sued, to interpret that law in favor of housing. And so there is a question about whether substantial compliance is enough here. And the risk to the city, if a court said no, is really significant. At the end of the day, the city, if it was sued, and actually it's currently being sued on this project, if a court agreed that the city did not comply with that inconsistency determination, and that inconsistency determination means that those provisions that weren't identified as inconsistent with the project, after 30 days, the project is deemed consistent with them. So if in its application of the CDP findings tonight, the city relied on those provisions and the court agreed that the city didn't sufficiently identify them in advance and they're deemed consistent, then the city could be found to have violated the Housing Accountability Act. And those are big consequences. There's mandatory attorney's fees, there are penalties, there are multipliers on the penalties. And so the city, when not just this project, to be honest, but any project that comes forward that has an Housing Accountability Act component, the city needs to very carefully review the requirements of that law because the risk to the city is so monumental. And so I think the difference in this project, because this has a Housing Accountability Act component, the council, it has been advised by me that there is a greater risk with this project than there was with the prior project. And so that results in, because the rules are a little bit different, it results in ultimately different decision-making, which is how the council is coming to its determination on this project.
That's helpful. And I know a lot of cities are challenging SB 9 on the basis of being a charter city and, different arguments. Have any of those prevailed? Are there opportunities that are successful where the city could, prevail in a challenge or, become a charter city and be exempt from these laws?
Not anymore, council member. There was a very brief moment in time where charter cities had challenged SB 9 a couple of years ago. They prevailed and there was an immediate legislative fix on SB 9. So generally speaking, the legislature has pulled the question of local control from a charter city perspective out of the housing laws and applies them uniformly across to both general law and charter cities.
Thank you.
So you mentioned the lawsuit that has been filed by the applicant, I guess on both projects, which I didn't really understand because the hearing process was still going on, but it appears we're moving to we already approved the first one. It appears we're on the verge of approving the next one. So what's happening to the lawsuit?
Well, I think our position from the city's perspective is that those lawsuits are moot because there won't be the basis for those challenges with an approved project no longer exists.
Because there's no denial.
Because there's no denial. There's an approval and an ability to proceed with the development of the project.
So it asks the applicant, is there going to be a dismissal of the lawsuits or?
And hang on, if we're going to have a conversation, either the microphone or this may be a little bit outside the scope, but if the applicant's willing to answer, he's.
All right, he doesn't want to answer the question.
Look, are these the final conditions?
Yeah, these are.
Yes, these are the two conditions discussed by the city council for your review and consideration.
Looks good to me.
Everybody okay?
Should we get the applicant?
Yes, I'm going to open public hearing and ask if the applicant can come forward, please.
Yes,
Do you,
I agree with the conditions as cited,
thank you very much.
and I assume they say 10 inches.
They do.
Okay, I will strive to do more. All right,
Thank you.
Thank you. Close the public hearing.
What about, can we change to, based on what you said, and we'll make all goods, so it's just guaranteed 10, you don't have to go beyond that, and we'll good faith efforts to achieve an overall height reduction of 1 feet or more. Sounds like the applicant's agreeing to that, so let's add that language.
Is that okay?
Should we get it? I think he confirmed, right? Yeah, okay. We're good.
Okay. Okay. Back to council then. Do I have a motion?
Can I confirm that does the resolution have other red lines? Are they the same as the red lines from the?
I think there's a minor definitional term project is defined.
Okay.
So, oh, yep, there it is. Oh, okay. Sorry about that. Thank you, city attorney. Okay, so actually scrolling up, Anthony, there are minor changes. There was a reference to a second revised project and then defining it as the project or the project. Then going down. Section 4, this is similar to the 1550 Bluebird Canyon Drive, which is a finding that the council finds that existing coastal resources that could be protected by discretionary design review findings are already protected by the discretionary coastal development permit findings. Accordingly, the city council finds that applying discretionary design review findings to protect coastal resources is either duplicative to the coastal development permit findings or unnecessary. A minor cleanup change in CEQA. And then the conditions of approval.
Mayor Orgel, if I could just make one clarification when Jane's done, which I think she
I'm
is.
done, thank you.
I think staff would agree that a crib wall for landscapes would not be practical in this situation. I think it specifically includes that language. So I think we could just refer to a living wall treatment and remove the reference to crib walls.
That was a good catch. Thank you.
Can we add or similar measures to that?
Should I, before we make a motion, should I open the public hearing and ask for another?
Well, I think we just broadened that condition
Okay,
a little bit.
so you think we're okay?
The consent is the same, yeah. I mean, we're
Okay.
good.
Just want to check, make sure. Okay, then, do we have a motion?
Yeah, so I guess I would say based on the limited ability under the Housing Accountability Act to deny in the absence of a public safety finding, which based on the testimony and memo from our fire marshal does not exist, I would move to overturn the design review denial and adopt a resolution as stated in option B, finding that the project is categorically exempt under Class 3 of CEQA, overturning the design review board's denial of the coastal development permit, and approving the coastal development permit and design review, and finding the approval of the project exempt from CEQA and I would with the applicant's consent, as he previously agreed to, I would include in my motion the resolution as updated on the screen.
All in favor?
You need a second.
No, sorry, second. All in favor?
Aye.
Aye.
All right. Opposed? None? Okay, it passes unanimously. Congratulations. Meeting adjourned.
I know we